Your Lordship, may I be allowed to mention a matter for inclusion under the heading motions?
Yes.
My lord, I crave leave to.
Please, Harshita.
My lord,
Yes.
I crave leave to mention one hearing matter, my lord. WPST hearing matter.
Hearing it is in the combined list.
No, my lord, for inclusion in the list, I am
Then you
mentioning.
mention on Monday. Give a notice to your other
Yes,
side.
my lord, I have already given
You
notice.
given a notice.
Yes.
My lord, may I be permitted to mention, my lord, one hearing matter before vacation I mentioned. What has happened, my lord?
But the slip, let us see.
Well, urgency is that, my lord, your petitioner, my lord, age is now, my lord.
Let it come in the list first.
No, listed matter. Listed
It is
matter,
in-
item number 276 of
Then
your
you
lord.
give a notice to your other side and mention for upgradation. Yes.
Well, I have given notice, my lord.
So today the combined list is not there. It is coming
Monday,
out
coming
in-
Monday, my lord.
So next week you remind.
Yes.
Yes.
Lordship, may I permit to mention the upgradation of one Cinder Tribunal hearing matter?
Upgradation matters. Let the combined list come on Monday. You mention with a notice, we shall call.
I have given the notice, Your
Inclusion
Lordship.
application group 6.
Pardon?
Inclusion in the list.
What?
Application group 6.
But the restoration
There are two
application may be
matters.
included.
Pardon?
Restoration application may be included, madam.
Lordship, for upgradation on Monday.
Mention because this number serial will be different.
Lordship.
Yes.
Your Lordship, may I be permitted to include this particular matter under the motion list?
My lord, may I be permitted to mention item number 29 of today's list, my lord? This is that the Jogesh Chandra College matter, my lord. Some precedents might be given, my lord, because the petitioner is out of service, my lord. And she is not getting any benefit, my lord.
Wait.
My Lord, may I be permitted to mention, my Lord, seeking Your Lordship's kind leave to file this appeal without the certified copy of the order, my Lord.
When
My
was
lord,
the order passed?
21st December. My Lord, I have applied on 22nd December, but till date I inquired that the file did not come from the court before the department, my Lord.
File এখানে নাকি? File is not with us.
No. My Lord, I am seeking leave, Your Lordship's leave to file this appeal without the certified copy of the order.
Granted.
Lordship, I have already given the notice. I have mentioned it in the month of December. Your Lordship have allowed my mentioning that, but I was informed by the court officer that I have to mention it again.
Has it come in the list?
It was reflected in the monthly list of December, Your
Is
Lordship.
it there?
Yes, Your Lordship.
So
Your Lordship
you-
allowed my mentioning.
Madam, mention it next week. When the combined list will come, your seriality will change.
I will again mention
Give
it.
a notice and mention on
mentioned
Monday, then we shall consider.
I have
Monday
already
or
given the-
Thursday next week. Yes. Call the list.
I'll be good and we are the respondents.
One minute, I am appealing for the petition.
প্যারাগ্রাফ 11 আর 13 এই 11 আর 12 রিলিজ করে দিয়েছে আর যে চাইছে
But here I am challenging the transfer order issued against the petitioner. That is page 28 and 29 is the order.
রিলিজ করে দিয়েছে রিলিজ করার পর অ্যাপ্লিকেশন করেছে রিলিজ অর্ডার
An impugned order is
Yeah,
page
just a
96.
moment.
পঁচিশ 12/2008 25/8 এই 25/6 11 নম্বর প্যারাগ্রাফটা একটু করে দেবেন মানে রিলিজ করে দেওয়ার পরেও করছে অ্যাপ্লিকেশনটা
Yes, page.
Well, at page 96 is the order passed by the State Administrative Tribunal.
No, your transfer order was of October 2022.
Two.
It was you were transferred from
From-
the post of UDC.
ITI Durgapur to Tung, Darjeeling.
Darjeeling. Now thereafter, did you have not joined the transfer post?
No. After that, immediately after that,
Back-
I made representation before the authority concerned. That was not unanswered. That was not answered anything.
So how
And
you are
after that-
getting? Are you getting your salary? No.
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 Huh?
He's not discharging duties.
And after that, I filed application before the tribunal. And immediately after that, so cause notice has been issued against me, directing the
20th October.
that my where,
How can we help you, madam?
because
it is a
my lord,
transfer order of October 2022.
yes,
And there is no malice in that. Any malafide you
my
have
lord,
said?
if your lordship can see the my advertisement, the advertisement in which I applied for, and on what basis I appointed as a
Do you want your job or not? You will sit at
obviously,
home.
obviously.
Then why you are sitting at home since October 2020?
My lord, page 17, my lord, for a moment, my lord, the advertisement that on what basis, my lord, I applied and I appointed. My page 17 of the advertisement.
Hmm.
My clause 4, choice of duties. My lord, the candidate will have to opt for one particular district from the schedule given below, and he or she will be considered for vacancy in that district only.
That was
According-
done at the time of appointment.
Yes,
So is there any provision that you will never be transferred?
there was no provision, and there was no provision for administrative ground also. My lord, my
Was the transfer order now?
administrative ground,
Show us the transfer order.
that is page 29.
29.
Yes. Page 28 and 29, the order.
P10. No, P9, P9.
P9 order P10.
This is your placement at Durgapur.
That is from, that is against
You
the
are- What is your
ITI
Arun
Durgapur,
Chaudhary? Yes.
presently holding the charges of store of ITI Durgapur as the storekeeper, is hereby ordered to be transferred and posted at ITI Tung on administrative ground with immediate effect to render his service there. Sri Chaudhary will hand over the charges of store of ITI Durgapur to Sri Prashanto Bose UDC ITI Malda after his joining at ITI Durgapur.
Yes.
Page 29. And after that, immediately after that, I made representation before the authority concerned, page 36,
What
stating
is-
all the things,
what
all
is-
the things.
What is page 31?
31.
Hmm.
28.
This is also another order issued by the
Please,
Municipal Industrial
Yes.
Training Institute. And immediately after page 36, my reply, my representation that my as per advertisement, there was no such transfer post on administrative ground.
Where
And-
is in the advertisement, where is the clause that once you are appointed, you will never be transferred?
As per my choice, they appointed me.
Right.
I choose the district of Burdwan.
Show us that my choice was this, you cannot transfer me in terms of where is that clause that no transfer order will be issued?
Transfer may be considered within the district.
Hmm.
If your lordship kindly say clause 4 in the advertisement.
This is at the time of appointment, madam. When you were appointed, you
Yes.
were asked to give a district choice, and it was said that you will be selected. If you are selected, you will be placed there. This is
As per my choice.
that is at the time of appointment, not subsequent. It
And
is
there
not a-
was, my lord, if your lordship kindly see in the advertisement, there was nowhere, my lord, for the transfer me from one place to another. They transfer me within the district. Within the district, my lord, they transferred me. But with the beyond district, my lord, jurisdiction, they did not. They cannot.
When did you file the original application?
Original application, that is, my lord, page 49 onwards.
No, when did you file it?
Yes, my lord. That was filed on 22nd 8 2023.
22nd 8 2020.
2023.
That is almost about 1 year thereafter.
And
Transfer order.
my lord, after that, I made a representation before the authority concerned, and immediately after that, they issued order that was page 46. Page 46 is my show cause notice. Challenging that, I filed show cause notice given on 24th 4 2023. That is page 46. Page 16.
Hmm. Hmm.
Yes. Anything else, Miss?
Malad, another notification memo is there that they cannot transfer me
Madam,
without.
save your service. Save your
Malad-
service first.
41 page 10 and 11
Malad, kindly come page 41. Page 41. The page 41, that is circular issued by the Principal Secretary, Government of West Bengal. Page 41, clause 10 and 11. Option for posting. Page 10. Serial number 10. Page 41.
What?
That is the West Bengal Service Recruitment to Clerical Cadre Rules 2010. I annex page 41.
Yes.
Page 41, serial number 10. Option for posting.
The serial number.
Serial number 10. Candidates shall be required to indicate their option for the vacancies in the departments or in the directorates, and also for district offices of one particular district only, to be named by them, stating the order or preference between the two. The vacancies is the departments or directorates only. Then, my lord, 11. Saving notwithstanding anything contained in these rules, the persons appointed on a regular basis or substantively to the posts covered under these rules, or in such cases where the process for appointment to such posts has been started prior to coming into force of these rules, the person shall be deemed to have been appointed under these rules.
This rule came into effect after you were appointed.
Yes.
In the year 2010.
2010, your appointment was sometimes in 2008.
2009.
9.
And this was came into force 2010.
How does
After
this
that,
help you? How does
my lord,
this help
after
you?
that, they issued my lord transfer order.
Yeah, where is the bar?
But there was no whispering about the advertisement. As per advertisement, my appointment letter.
Try to understand. Advertisement was at the time of appointment. At the time of appointment, there is no bar under the advertisement that once you are appointed, you will never be transferred.
My lord, on the basis of the that advertisement, I applied for, and I choose my district, and they appointed me in the district of
No, in
Bardwan.
in the notification where in the advertisement you show us where it has been stated that once appointed will not be transferred. If you rely on that, you just point out where it has been stated once appointed in that particular district of your choice will not be transferred. Where is that?
My lord, that was also not stated in the advertisement.
So
that
that means of your choice will be appointed, subsequently will be transferred. That's what you can take.
And they did not reply my they did not reply my representation against the so cause
Then
anything.
why you have not see October 2022 your transfer order, but you filed only in August
My lord,
2020.
several representation and so cause in the reply of the so cause I filed before the authority concerned. And my lord, on the medical ground, that reply has been made. My mother is a cancer stage 3 patient, and my father also is a aged person. I only the family member look after my mother and father, and for that reason the representation reply in the show cause I made, they did not reply till today.
Hmm. Yes, Mr. Mukherjee.
What can you see? Advertisement was made for filling up the post of LDC. That is at page 17. And there is a distribution of vacancy district wise. Page 17, kindly see. Just prior to choice of district. South 24 was not 24 was Howrah, Hooghly, Bardon. Bardon total 29 vacancies were there. But every candidate was given the option to exercise choice of option in case of appointment only. Only case of appointment. But just like doctors, if somebody choice of exercise in the district of Calcutta Medical College or North Bengal Medical College or Bardon Medical College, they were given the choice of posting. Choice of posting was there. It was never said that under the WBS or West Bengal service rules, nobody can be transferred.
They are specific.
And 22nd October 2022, he has been released and service book has been transferred to his transfer post of posting. He did not join.
She has not yet, her salaries have been stopped.
Automatically.
Oh, automatic stopping.
But because as soon as service book is transferred, then everything goes to the treasury officer of that district, Darjeeling district. On that date, he joined because you will automatically get salary from that district. Now payment is made on the economic.
Clause 11 is given retrospective effect. If you are page 41, serial number 11. Given retrospective effect.
No, the Chakraborty is not there. He was posted there.
No, Durgapur is district.
Which district it will come?
She was posted in Durgapur first.
Durgapur.
That is within district.
Of now it is Purva Bardhaman. It is your district of Bardhaman initially. 2009.
So that Bardwan is here in your list.
Kindly see.
Yes, Bardwan.
Bardwan total number of vacancies 29.
So she was posted there.
Posted there.
And,
choice of
she was posted there in which year?
2009.
2009.
Then he got promotions, LDC to UDC.
UDC.
Oh, he got promotion.
In the year
because of the
2014. 2016.
Thereafter, the transfer order was in 2020.
And he has been released on 22nd October.
And my lord, kindly say for a moment, choice of district specifically stated, my lord, that given below and he or she will be considered for vacancy in that district only.
That is what they have done. That is what they have done. They posted, you wanted Durgapur, they posted you at Durgapur.
No, he choice of exercise was posted for.
Mr. Mukherjee, take your seat. She is already in trouble.
Well, my choice is Bardhaman. Well, I join at Bardhaman.
Save your service. You will be terminated. Go and join the transfer post. Then make an application. Then come to us. Why? Because this is a problem. Your salary has been disturbed. You are not being allowed to join. So try to consider, please do not lose your service. They will terminate you for this unauthorized absence from 2020. The president.
That save at least that protection we can give. That's a good item. So focus notice already has to face there.
Did you reply to the show cause notice?
Yes.
Then
Now any disciplinary proceeding initiated?
When a disciplinary proceeding is contemplated, so cause notice has been issued, certificate not satisfied, but when a till date
Proceeding.
charge sheet has not been issued.
The present writ petition.
That is
has
page
been
34. My lord, kindly direction may be given, my client willing to join there, then file application, then because his salary already stopped.
Go and join. Why?
My lord,
We are not
kindly because as the direct tribunal already dismissed my application and
Go and find out.
my mother is suffering from cancer.
Huh? What do you say? But now,
Let him resign.
what have been changed in circumstances?
And that vacancy till
Let him resign from the post, then he will see.
new vacancy where we
Under the law, he is not getting automatic termination.
Dismiss it. We will have no other option but to go and join.
কিছুই পাবে না, কিছুই পাবে না,
after
20 বছর হয়নি, কিছুই পাবে না।
filling vacancy.
But can we go into
ও চাকরি চলে যাবে। কারো রক্ষা করা
Mr. Mukherjee,
What?
is the vacancy you can allow, she can go and join at,
any day. Any day he can join, but this unauthorized absence has to be regularized first.
no, that is an issue for your disciplinary. proceeding.
No, when first he shall have to apply for regularization of his unauthorized absence from 22nd October 2022 to 24th January.
Yes,
First, that if it is regularized, then he can get salary or half pay or full pay, whatever may be there.
we are not on that. We are asking that is the post still there?
It's
Whether
still there.
Huh?
Because service book has been transferred.
to allow him to join in the transfer.
No, what is transfer order is there. It has not been touched by the government.
No, but if after now, if he goes to join,
Hmm.
you will not allow him to join, may not allow him to
No,
join.
but he shall have to apply for first apply for a regularization of unauthorized substance.
Then you are again mixing the departmental proceeding.
No. Just formal application has to be made.
No. For that, you allow him to join.
Yes.
Thereafter, whatever the consequences you start.
Yes. Let her go there and join with an application that because I could not join there.
Subject to result of each.
Yes. See that because I want to transfer.
Whatever you can say. Common submission factor, which is open to the
বলে দেবো ডায়াস নয় কতটা বলে দেবো
Cannot say that.
that cannot be regularized.
না ডায়াস নয় অটোমেটিক হবে
That vacancy is still there. On
still
its
there
own.
and but now we have hands are beyond our control because of unauthorized substance. This period will be treated as a dias non.
You are declaring the result before examining the examination.
No. What are later
You are
join there?
declaring the result.
No. Under the rules. I'm not saying that.
If he joins,
Joins. He can
once
join.
he joins,
Yeah.
suppose I join today. Whatever the consequences for the alleged unauthorized absence, you are free to take. that.
Yes.
There is no problem.
No, there is no problem, but she'll have to
So
find
we will record your submission that he can always go and join the
join the
transfer.
transfer of posting with a formal application to regularize his absence.
After joining, I file application.
No,
Regularization.
before joining, he shall have to file an
After
application.
joining, the consequences.
Then you withdraw the petition, go and join the
No, my
transfer.
lord, kindly order record the submission and my lord kindly one order, my lord, I willing to join and my lord kindly because they did not join me.
See, if we dismiss the petition, understand the consequence. You go and you withdraw the petition, you go and join.
My lord, tribunal dismiss my application.
The present writ petition has been preferred, challenging an order dated
আমরা পেন্ডিং থেকে জয়েন করেছি
1st of December 2023,
তখন আমি আসবো।
passed by the learned tribunal in the original application being OA 595 of 2023. Pending. What do you feel?
Otherwise, we can we can issue such direction. Submission of worksheet completed. There is a vacancy. So let the form join subject to the so custody.
What do you?
So let him participate, let him join, let him participate.
3 years we go into inspection. It's an order to
Okay,
being
okay.
shared.
Oh,
Miss Dhobul learned advocate appearing for the petitioner submits. That the transfer order she is inviting her own problem. They do not understand.
given the presentation.
Hmm.
After joining the plate for leave and
We are dismissing it. We will record his submission. This will be more
কিছু বলছো বুঝতে পারছো?
for come here.
join the transfer post, yes or no?
Yes,
Huh?
yes,
Then you go to the post and join first.
yes.
Go to the post. We are not interfering with the order of the tribunal. As Mr. Mukherjee says, that he will go to your place. You allow you to join, subject to whatever consequences that will follow. Then you first go and join. Tell us and withdraw the petition.
Yes.
চাকরিটা রাখতে চাও না রাখতে চাও?
চাকরিটা রাখতে চাই তো খাবো কি?
চাকরিটা থাকবে না কো, রুলসে বাধা আছে, রুলসে বাধা।
খাবো কি না?
তোমার হবে না,
This matter becomes
চাকরি চলে যাবে।
যাবে না করে জয়েনটা
ডাইস নন হয়ে গেছে,
এই
সেটা জানো? ডাব্লিউপি সেটা জানো? ডাইস নন বলে একটা
না পরে ফেস করবো ডিসিপ্লিন
ফেস করবে, সারা জীবন পেনশন পাবে না।
না হোক তা আগে জয়েনটা করি।
গিয়ে জয়েন করো তো। এইসব করে কেউ মামলা মোকদ্দমা কেউ করে পয়সা নষ্ট করে? তোমার পয়সার জন্য হচ্ছে, কিন্তু ওর তো পিছনে বম্ব হয়ে গেল।
এখন ট্রাইব্যুনালটা ঠিকঠাক করলে তো আমি জয়েন করতেই পারবো না। আমি তো এখানে ট্রাইব্যুনাল তো অন্য লোক করছে।
এখানে আসার দরকার কি?
Mr. Mukherjee, we can record that the vacancy is there.
Yes.
Ashok, in course of hearing, Ms. Dhobul learned advocate appearing for the petitioner submits that the petitioner is willing to join the transferred post. Answering our query, transferred post, that which is the willing to
তুং দার্জিলিং, ITI তুং দার্জিলিং।
টুং টুং
টুং, TUNG।
টুং।
লাস্ট পেজটা চলে যান, একদম লাস্ট ওখানে গেলে পয়সা দিয়ে ট্রান্সফার। ITI দুর্গাপুর।
he has not handed over charge.
রিপোর্ট দুর্গাপুরে আছে।
হ্যাঁ, দার্জিলিং, ITI দুর্গাপুর, ITI টু দার্জিলিং।
And
You handed over the charges.
no, he has
Did you
not
hand
handed
over
the
the
keys.
charge of your?
No, but he has not handed over the keys of the Almeidas.
He has not yet handed
Handed
over.
over. 3 reminders have been issued.
Your conduct is not proper. So you are withholding the state from appointing somebody, you're disrupting the entire services of
Our
ITI.
students are suffering.
Malat within
You have not, have you handed over the charge and the keys as asked for or not? Tell us.
No.
Then for 1.5 years, this stalemate is continuing.
Keys are not with me. I am not. Keys are not with me. Keys are not with me. I am not. No. I am not legally authorized to keep the keys. I am only liable to maintain the records.
Malat keys not with the my.
Where have you stated?
Malat that is last letter issued.
You have not handed over the, you have
Keys,
not,
Malat,
In my reply letter, it is stated.
you have not handed over the charge.
Malat keys is not with me. Only
We have
record
already
and,
registered an FIR. We have already registered an FIR. Because
Where is that?
Tapabrata page 98.
98.
98.
Yes. But the last two paragraph. Now recovery of the key store of ITI Durgapur is essential to access the store which she Ayan Chakraborty is still possessing illegally.
98.
98.
Where you are saying?
Just above
to access the store. Which, yes, now recovering the keys. Got it?
what can I do except lodging an FIR? We shall have to run the administration.
Yes, Malat, that is issued on 11/12/2023.
I have replied on 15th that the keys are not with me.
After that, Malat, page 99, my reply.
That will be investigated by the police.
15/12/2023. Page 99.
I have also given supporting documents that the keys are not with me.
Malat, that is para 3, Malat, I specifically stated.
Because he wants to stay at Durgapur, he is making all these troubles.
That is a disputed issue. According to them, please according to him, I am not having key. No, who will decide this? This we cannot decide. The jurisdiction we cannot.
I'm not the attachment to the that I am the possessor of the keys. I have also given the proofs.
No, sorry, Ms. Dhawal. Conduct does not appear.
Malat, that page 99, Malat, for
Either you withdraw the petition and go and join the transfer post, face the consequences.
Malat, they did not allow me, Malat, to join. Malat, now I am willing to join. Malat, the original application before the tribunal that was dismissed.
Oh, that itself, these issues are not before us. We are on the issue of transfer. Now you are saying I'm willing to go and join there. You go and join there. We do
Malat,
not
kindly
Either you
painting the application, Malat, within a week, Malat,
that is not
I joined there and came back before your lordship. Malat, everything, Malat, the statement they made, Malat, that is not with the keys, not with
That is
me.
why we are not in a position to go into such disputed questions. It is a fact that you are not working. Good, bad, indifferent, there is an unauthorized absence to which they have already
Malat,
taken
as
action.
I tried my luck before the
You can try your luck by
state tribunal.
withdrawing the petition
Malat,
and go and join.
Malat, kindly, Malat, because the cancer patient is, Malat, my mother is a stage 3 cancer patient. Her treatment is going on. Malat, so, Malat, I am
For
praying.
that, how can we can try to understand? 2022 was the order of transfer. We are in 24. Your subject matter of challenge is the transfer. Now you are saying that after wasting time for 1.5, 2 years, you are now saying I will go.
Malat, there are several communication between the department and me. I tried my luck before the tribunal. Malat, now, Malat, kindly, Malat, I
can simply adjourn.
If you permit,
So if we say that the submission now has been preferred, challenging the order dated such and such passed by the learned tribunal in the original application being such and such. Ms. Dhobul, learned advocate, appearing for the petitioner, submits that the petitioner was illegally transferred from the post of storekeeper
Storekeeper.
from the post of storekeeper at ITI Durgapur to ITI 2 in the district of Darjeeling by an order dated 20th of October 2022. Stop. The said order
এটারও দেখুন সব হয়েছে এটা সেক্রেটারিয়েটের উইদিন সেক্রেটারিয়েট ওই রুলের অ্যাকর্ডেন্স
by an October by an order dated 20.
Upper division clerk you mentioned.
Mhm.
Storekeeper or upper division clerk?
Where you have said it.
Page 6, para 9.
এই নোটিফিকেশনটাকে সরিয়ে নিন নোটিফিকেশনটা এইটাকে ছিঁড়ে নিন ছিঁড়ে নিন এইটাকে ছিঁড়ে নিন এইটা দিন
Promoted.
সেভেন 165
Oh, yes. Upper division.
এই ছিল সেক্রেটারিয়েটের ব্রাঞ্চ
Upper division storekeeper is UDC post.
Yes, upper division post. There is no curtailment of pay. There is no curtailment of pay. Same pay scale.
Upper division storekeeper.
আপার ডিভিশন ক্লার্ক নট স্টোর কিপার আপার ডিভিশন ক্লার্ক স্টোর
Upper division clerk store.
আমি তো স্টোর কিপার
কি লিখেছো? Ms. Dhobul, learned advocate, appearing for the petitioner, submits that the petitioner was initially appointed
একটা সেক্রেটারিয়েট থেকে আরেকটা সেক্রেটারিয়েট হলো কিন্তু সেক্রেটারিয়েটের
as a lower division clerk after he emerged to be successful in the selection process. After he is initiated by an advertisement being number 14/2008. Subsequent thereto, he was promoted to the post of upper division clerk and was working at ITI and was working at working in ITI, Durgapur. Stop. The clause 4 of the advertisement specifically provided that, quote unquote, the candidate will have to opt for one particular district from the schedule given below, and he stroke she will be considered for vacancy in that district only according to her option. In violation of such condition, as specified, the petitioner was transferred by an order dated 20th October 2022 from ITI Durgapur to ITI, Tum in the district of Darjeeling. The said order, according to Ms. Dhobul, the said transfer order was also not in consonance with the West Bengal recruitment to clerical cadre, bracket close rules, 2010. Stop. Such issues, as urged were glossed over by the learned tribunal, and without returning any finding on the same, the original application was dismissed by a cryptic order. Stop. Such infirmity warrants interference of this court. Stop. Ms. Double further submits that the submits that after issuance of the impugned order of transfer, repeated representations were submitted by the petitioner. Repeated representations were submitted by the petitioners, but the same were not responded to. Stop. Aggrieved thereby, the petitioner was constrained to approach the learned tribunal. Stop. Mr. Mukherjee, learned additional government pleader appearing for the state respondents, denies and disputes the contention of the petitioner and submits the transfer is an incidence of service. Stop. On administrative ground, the petitioner was transferred from ITI Durgapur to ITI Komatung in the district of Darjeeling. Stop. Stop. The petitioner deliberately did not join the transferred post and had continued in unauthorized absence till date. Stop. In the said conspectus, the learned tribunal did not interfere with the order of transfer, and there is no infirmity in the same. Stop. Heard the learned advocates appearing for the respective parties. Appearing for the respective parties and considered the materials on record. Stop. Next para. Transfer is an incidence of service, and such order should not be interfered with unless the same is palpably illegal, arbitrary or malafide. Stop. Stop. Records reveal the argument of Ms. Dhobol that the transfer order had been issued in derogation to the terms of in derogation to the conditions contained in the argument of Ms. Dhobol that the transfer order was issued in derogation to the conditions incorporated in the advertisement by which in the advertisement is particularly clause 4 of the same, is not acceptable to us. Stop. Such conditions were applicable when is not acceptable to us. Stop. The transfer order was issued on 22nd of October 2022, and the petitioner approached the tribunal almost about 8 months thereafter, in the month of August 2023.
10 months.
About 10 months. Or 8 months, not 10 months. 10. Stop. 10 months. Stop. About 10 months there. Stop. For such unauthorized apps, about like
কম্পিউটারে দেখা যাচ্ছে
in the month of August 2023. In view thereof, we do not find any infirmity in the order of transfer, and as such the learned tribunal in our opinion rightly did not exercise discretion in favor of the petitioner. Stop. Accordingly, no interference is called for in the present petition, and the same is dismissed. There shall, however, be no order.
Kindly, one order, my lord, I am willing to join, my lord, kindly, because, my lord, after that several communication has been made between the department and me, I also replied my
Go and
regarding
join.
FIR.
Go and join.
Malad,
We have
if
no.
any order, Malad, your lordship pass, Malad, they did not
Next.
allow me to join.
If they do not allow you to join, that is a fresh cause of action.
Malad, then my learned senior friend submission maybe Malad recorded that if I wanted to join Malad at any time, they can join Malad submission, Malad only. Submission can be Malad made by my learned senior friend. On that basis, I am Malad try my luck.
Mr. Mukherjee submits. Mr. Mukherjee, however submits that the petitioner is free to go and join the transferred post subject to the discipline. No, free to join the transferred post at ITI 2 in the district of Darjeeling.
Subject to compliance of all formality. ITI 2.
After that, formalities will come. First.
After complying all formalities.
Mr. Mukherjee, however, submits that the vacancy in ITI 2 in the district of Darjeeling is still existing, and the petitioner is free to go and join the transferred post. Yes. Huh? Yes.
Great. Great.
Again, let transfer. Now, in my case, it's a punitive transfer. That I am a teacher of a polytechnic, and that I made complaint that the results which we have uploaded in the website has been manipulated. That complaint we have made.
We have made means
I have made, brother, the teacher.
But the matter is that.
Now, based on that, inquiry committee has been constituted. I am a member of that inquiry committee. Though according to me, to do independent investigation, they should take.
But the main matter has been fixed on 25th of January. Tribunal matter is pending.
Now,
pending.
Yes, 25th of January.
Tribunal has admitted my petition, but no interim order. Admission itself shows that there is a prima facie case.
So what?
Therefore, the interim order should be passed in while the case is a case of transfer.
What is the prayer in this?
But if your lordship kindly takes up the transfer policy.
Wait.
Yes.
That is prayer here. G.
This place, Kolkata, I have checked in the net. 400 kilometers away from Kolkata.
Yes, tell us.
Kindly takes up my complaint at page 46.
46.
Yes, may I read? Kindly date is very relevant. 18th August 2023.
So where
according to me, this is the reason for transfer. I'll demonstrate. This complaint I have made on 18th August 2023 at page 46.
No, you have already been released. You have been transferred and released. What interim order do you want?
Stay of operation of the impugned order of transfer. The order of transfer.
That you go and argue before the tribunal.
No, unless I shall argue.
Yes, on 20.
Unless there, in the meantime, there should be a stay.
What stay? We cannot pass meaningless orders. You have
this
been transferred, you have been released. What interim?
If the entire thing is illegal, High Court has ample jurisdiction to stay it. Subject to stay the order of transfer and the release. All consequential orders.
Release order has been issued. The transfer order has been passed. Now tribunal has fixed the matter.
Release
on
order,
Tribunal has fixed the matter on 25th January.
Right.
Why you have come to us?
Mlad, immediately on the day of the impugned order was passed by the tribunal, Mlad, I have approached this honorable court. Since the order was not uploaded, it was delayed by 1 day. Now, Mlad, the leave was granted.
Which was delayed?
My filing of this writ petition was delayed by 1 day since the order was not uploaded by the tribunal. Now, Mlad, immediately the leave was granted, I filed the writ petition. Now, Mlad, order of release issued pursuant after the filing of the original application, and the order was passed by the tribunal.
So when was the transfer order? It was 9th October.
9th October.
And the release was on?
December 6. And that too, can you see the last line of the release order? My salary was not transferred.
6th of December 23.
Yes. That is after filing of the
When did you?
Original application before the tribunal.
After filing?
Yes.
When did you file the tribunal?
November 28th.
28th November?
Yes.
Transfer order was served on October 20.
And transfer was served on October 21. Immediately after reopening of the college.
The transfer order was 9th of October 23.
Served on me on 21st.
21st October?
Yes. Immediately when I approached, before the order of transfer was...
Just a...
Yes. I'm sorry.
It was served on 21st October. You filed in 28th November. That is about a month thereafter. And thereafter, they issued the release order on 6th of December.
6th December.
To show us the order of transfer.
Now, the order of transfer is at page 53. Governor is pleased to transfer the below mentioned lecturer, Government Polytechnics, born in the West Bengal General Service, on the administrative ground.
The governor transferred the lecturer of government.
And only my name is appearing.
Yeah, from Calcutta to Dakshin Dinajpur.
Yes.
Yes.
Now, kindly takes up
You say that it is malafide.
Kindly takes up page 46.
Page
46. Now, kindly date is relevant, 18th August of this year, of the previous year. Previous year. With reference to the subject, this is to inform you that you are well aware that the marks uploaded by the faculty members of the institution for the last odd semester students of the institution for internal and external theory and practical subjects have been tampered in the council's website. A serious allegation. After discussion with the faculty members of the institution, the passwords given by the council have been changed and all the subject teachers have corrected the tampered marks again in the interest of the student on the last date. I would like to inform you that the marks of 3 students have been increased and 2 students have been decreased in the 3rd semester DME students in the council website uploaded by me on the subject mechanical engineering and drawing. The marks of 2 students have been decreased in 1st semester DCE students in the council website uploaded by me for the subject engineering graphics. It has been found that the above mentioned cases have taken place in every subject. After detecting unwanted matters, the institution has not taken any steps to find out the person involved with the aforementioned conspiracy. I think it's a gross violation of the academic activities and unconstitutional activities in the eye of laws. I think this practice is going on last few years in the personal interest of someone who is tampering the marks behind. This was serious allegation I have made. Now, kindly takes up page 49. Now, a committee has been constituted by an order dated 22nd August 2023 to investigate, and I am a member of this committee. My name is appearing in serial number 6.
You are referring to council. What is this council?
This council is West Bengal State Council of Technical and Vocational Education. In their website, we uploaded.
How that is involved with your institute?
No, this is Polytechnic.
Polytechnic. But there is a
They are
council.
not parties to the petition.
No,
Council is not a party.
I'm not concerned with the council.
No, the council constituted a committee for going into this.
No, this has been constituted by the Calcutta Technical School, my institution.
No, your allegation in page 46 is, it is addressed to the principal.
Yes, of my institution.
Faculty, the password given by the council have been changed.
Yes, my lord. Council gives us passwords. We to access their website so that we can upload the marks of the student of my institution. Now, that has been tampered with.
The council is the
That's
exam.
why I have made complaint. And I have said this is going on for last few years.
Yes.
And somebody is involved.
Now, this
Now, kindly see page 49. The committee has been constituted, and thereafter, kindly takes up page 51. This 51 is again, before the order of transfer was issued and was served upon me, rather. And I say, there was a pressure, I didn't mention that. All that I said that I am suspecting victimization because I made this complaint. And this letter I have submitted before the order of transfer was served on me. And the consequence follows. And I have made my twofold of prayer. Now, this is a serious.
9th October order.
প্রেয়ারটা কোথায় আছে দেখো তো, ওয়ের প্রেয়ারটা দেখো। না না না, ওটা নয়।
এই তো রিলিফ শট।
না না, রিড ওখানে থাকবে না।
এই তো।
এটা ঠিক না।
10th October, this is 9th October. So, yeah, before transfer, he sent a letter. But that is after transfer.
No, after service of the transfer. Service transfer of the
20th. October 20.
Has been released. Can we say that?
Punitive transfer. According to this punitive transfer, since he made a complaint. And 400 kilometers away from the place, that was hill station or something hilly polytechnic.
এটা ঠিক, কোথায় দাও আমাকে?
Now the release order has already been issued.
So these are then going to receive. That release order you received already.
No, release order I have received. Can you see the release order also,
That you received already.
Yes, I have received. I have received, and the last line 6th December, that is, after filing of the petition before the tribunal.
And the release order was not before the challenge, before the tribunal.
In that respect, I have twofold of submission. First, the last line of the release order.
Where is the release order?
Page 57. Can you see the last line? My salary has not been transferred. On hurry, they have issued this because I have filed this. I have challenged the order. Kindly see the note, note of the release order. Due to some unavoidable circumstances, HRMS release will be executed later.
What is HRMS?
The Human Resource Management System. That's basically the salaries, transfer of salary. But since I have filed the petition, they have immediately issued the release order. Again, malafide.
So now what interim order you are praying?
Lad, if it's a punitive transfer, I should not suffer for even for a single day.
Set aside. It has to be set aside.
It has to be first stayed so that this can be adjudicated and then set aside. Your lordships can marry.
No,
Well,
what we will stay today? If we stay this today, if it is a question, your argument is that the transfer order must go because it is punitive in nature, and the sequence of facts would reveal that they have proceeded in a mala fide fashion. This issue has to be considered by the tribunal. Tribunal has fixed it on 25th January. Now today you are asking for stay of the release order and the transfer order. Transfer order and release order, if we stay, what will be the consequence? You must be allowed to join.
allowed to join, yes.
So you want to join there so that in the meantime it will be considered by the tribunal. But how can we do so once you have been released and your release itself is an instance of punitive measure?
Right.
That you will argue before the
But
tribunal.
that I can always argue, my lad, two things.
Moreover, the order does not reveal the 19th of December 23. This argument which you are making, that is not reflected in the order also. It is not said that your interim order as prayed for is refused.
That's why, lad, I have, that's the whole difficulty before the tribunal. That's why, lad, what I have done, lad, I have not specifically pleaded in my petition that this submission was made and not recorded.
Go to the tribunal.
Blood, if the tribunal doesn't record, what the advocates can do, advocates can make submission. I don't make any aspersion on the tribunal. But I can just narrating the facts. I'm making the submission on facts. Blood, what has happened?
That the law provides. Law provides that you have to go to the court.
Blood, kindly visualize. I am a employee. If I don't join, blood, this period will be to consider as an unauthorized absence. Now, blood, the order itself I can demonstrate from the records available with the blood petition that it's a punitive transfer. Now, blood, if it's a punitive transfer,
It's on 25th January. Then now,
blood, stay till that time so that this period cannot be treated as, because blood, if this is if
received the release order, you go and join and contest the case before the tribunal.
blood, assuming that transfer order was issued today and the release order was also issued on the same day, and if I can demonstrate, if I can demonstrate,
receive the release order, you would have protest at least you would have made.
Immediately, yeah, blood, immediately after the release order was issued, not after filing. So protest was already there. The release order was not issued not before filing. Release order was issued after filing.
Already I have filed challenging the transfer.
Right.
Therefore, I am not receiving. You have not made such affirmance.
Blood, if I refuse, again, that will be misconduct. That's the whole. You have to kind of visualize from the angle of an employee. Now, here, for example, if the order of transfer and the release order is issued on the same day, and if I can demonstrate that the order of transfer is illegal, it's punitive, but whether the reach court has jurisdiction to stay that order or not, that's the question that has to be decided. Now, according to me, subject to lordship's correction, that if I can demonstrate that this is a punitive transfer, I should not be made suffer for even a single day. That's the law decided by the Supreme Court. And on the similar facts, but I have a judgment of up to 2023, rather than 2020. Kindly take some for your lordship's perusal. Only one paragraph, I will not waste your lordship's time. Here also, the interim order was passed. Kindly take some paragraph 4 first. Facts. And then 25.
volume 19, page
Paragraph 4. In the course of her representation, the respondent submitted that during the course of previous 2 years, she had, as a branch manager, inquired into the concentration of accounts maintained by liquor contractors at the branch and had detected grave irregularities which were hazardous to the interest of the bank. The respondent had submitted a detailed report to the zonal manager, Bhopal, on 31st December 2016. In her report, she made several observations about lapses such as existence of duplicate bank guarantee registers. She had recorded that the registers were not identical and some entries are missing from the new register. These are the irregularities pointed out in paragraph 4, then paragraph 7. The order of transfer was challenged before the High Court of Madhya Pradesh. During pendency of the proceedings, order of transfer was stayed by the non-single judge. Then kindly, yes, 25. Then kindly take some paragraph 25. The material which has been placed on record, paragraph 25, that the respondents had written a repeated communications to the authorities drawing their attention to the serious irregularities in the course of maintenance of accounts of liquor contractors, and in that context had leveled specific allegations of corruption. The respondent was posted on so-and-so to a branch which, even according to the bank, was not meant for the posting of.
This is arising out of an order by which it was transferred order was quashed by the learned single judge. It is not an order at the interim stage.
No, interim stay was granted. Paragraph 7, I follow. What I'm trying to submit.
Don't show as our judgment which is not in the applicable in the facts.
Now, the fact only for the reasons that since somebody has made complaint of corruption, he was made.
What is the
he is not interested in that. He wants that. I will not.
On the face of it, it is purely on that you can see. Context. The tribunal has taken up the matter.
Till then, no.
Till discuss the
initiating disciplinary punishment. But
definitely.
in these times, happens we say that you transfer
Otherwise, for another service.
yes, so that
Definitely,
is also no coercive.
So, sorry.
Honorable Kanishi. On administrative reasons, somebody has been transferred. He has made certain allegations that would be adjudicated by the tribunal. And at this stage, if transfer order is stayed, then what is the consequential effect of the release order? Release order was not before the tribunal, and whether the release order was good or if it is release order is issued immediately, then you will judge the malafide actions. They have waited for few days for some other reason. But a release order has been issued. Let him join there, and whatever his reasons is there, that will be contested after hearing the tribunal found. So no, there is some material evidence on record that there is a malafide transfer that would be adjudicated by the tribunal. Let him join in the transfer place of posting subject to the
That is his parent challenge before the tribunal.
But
He
if
is challenging
today,
the transfer order before the tribunal. Now, suppose he has, the tribunal has fixed it on 25th. Today, suppose if he has not joined, you take disciplinary steps.
no, that cannot be done. Your lordship knows that. Let him join there without prejudice to the rights, subject to the decision of the original applications. Let him join there without prejudice. He can write that without prejudice. I am joining in the place of posting, subject to the decision of the original applications. Nobody is preventing him.
What remains of his challenge?
No. without prejudice. If somebody accepts, somebody that without.
Tribunal will hear it after say 6 months. What will be the fate of the litigation?
No. If somebody works for 3 months or 2 months, January or maybe February or March, I'm not saying that. It may be finished on 25th January, it may be finished the first week of February, but it will be decided within 3 months or 2 months. We shall have to run the administration, my lord. Kindly consider that. We are not taking any penal actions. Just we have issued the on the administrative reasons. Let him ask.
What is the administrative in the ground?
Administrative reasons, we cannot disclose in and you had accepted for the public interest.
So in the mean, what is the
There is no such definitions in the service jurisprudence. Only public interest is there, nothing. If I issued it by a demotion or
Don't take
this
any penal measures against him.
this is college? See, if he transferred in between, definitely students will suffer. At least April, May,
or let him join there.
academic year, in between the academic
Let
year.
him join there.
Council, you tell what is the administrative reason to transfer him in between the academic
We
year?
are not supposed to disclose everything, my lord, because
Yes.
Ah.
So, academic year start, from which month academic year starts?
it is that administrative reasons are that when there are some.
No, academic year, see, in between, he is the, what is his?
That is for the administration. That is not for me. That is for the
Oh.
administration.
A question is being put to you that if you transfer a teacher in the midst of an academic session, then the students are the sufferers.
No, that protection has been given to the so far as students is concerned.
So
Can
have you brought anybody in his post at
you see the transfer order that page? Just give me a minute. 53. And committee has been constituted on the basis of his complaint.
No.
53.
Lecturer in mechanical engineering is transferred,
Yes.
but in his place, who was posted?
If somebody was not there or there, that does not appear from the order.
Who is posted in his place? Anybody posted?
That I do not find from this order.
You have not posted any person in his place. You have transferred it in the meantime.
It might be that that person was
Might be, maybe.
We do not know, Malada. We will go by the order.
You, huh?
We will go by the order.
Yes,
So
we
you
are.
have to get instructions.
You tell us that somebody else have
That
already.
instruction I have not received, Malad. I'm frankly speaking,
Then
Malad.
take care of the interest of the students.
Malad,
Who will take care of the
the
interest?
principal is there. Administrative body is there.
What is administrative body? Say, you answer us.
The principal is
Administrative body,
there.
what steps they have taken?
A principal is there. Principal is the academic authority, head of the institution. If he faces any problem, he immediately report to the government and then immediately steps should be taken. Students should
Then
not.
what is the pressing urgency to transfer him there? What is the pressing urgency?
It is for the interest of the public. It has been transferred for administrative reasons.
Not interest of public. You see, what is the interest
Then
of
nobody can be transferred. If Ballard holds that public interest has to be disclosed, then nobody can be transferred. Even a honorable judge cannot be transferred.
So generally in the colleges, when will be the transfer order will be effected, given effect? In colleges, you tell us. In colleges like this.
Kindly can take it otherwise. When honorable judges are transferred.
Why you are mentioning the judges about issue?
No.
What has this to do with that?
No, Ballard is asking.
Question has been put to you.
Yes.
You may say that I don't have the instruction who has been asked to work in his place.
Yes. I have no
You
instruction. I'm
cannot
saying
say
that.
we can do anything we like, we will not disclose.
No, administrative reasons.
You have been put a question by the judge
Yes.
as regards the transfer of a lecturer.
Yes.
Why you are bringing other issues?
No, I'm just giving example.
No, don't give example. We understand examples.
That example.
If somebody is transferred with the administrative reasons.
All right, you come and tell us tomorrow that whether any other lecturer has been placed in his place or not, and whether that person is working on it.
Yes.
You let us know tomorrow.
Can you take it next week? Any day convenient to all of you. Because I shall.
This is Durgapur, na, Mr.
No, Mala.
Calcutta.
This is Calcutta.
Calcutta, I shall have.
Come with the instruction tomorrow whether
No,
somebody else have
instead
been
of tomorrow, can you take it?
No,
Monday?
nobody has been.
Monday.
Tomorrow is Friday.
Tomorrow is a Friday.
Yes, tomorrow come.
Monday.
Tomorrow you come.
No, but I do not know whether I will be able to.
Nobody has joined, but I have taken instruction.
No, but I shall have to inform in the afternoon.
Inform Mr. Mukherjee.
Dear,
we are
I shall inform after.
very good. We are keeping it tomorrow. If you are in difficulty, you tell us. Yes, next.
For item number 3, praying for a week's adjournment, Lordship. The service has not been completed, Lordship.
Service not completed. The 2 weeks করে দাও।
Deeply obliged, Lordship.
Yes, next.
Should I appear for the respondents?
Respondents.
Yes.
Who is your others? First time it has come.
Yes, first time.
2 weeks.
2 weeks. No.
Item number 5. Yes.
From the petitioner.
Yes, tell us.
I filed a writ petition, my lord, WPA 7832 of 2020 on 29th September 2020, my lord, challenging a premature retirement order, a purported premature retirement order, dated 16th September 2020. For expeditious hearing, I filed an appeal, number MAT 219 of 2021. Nothing was proceeding. So the WPA 7832 of 2020 was withdrawn, my lord. I withdrew it with leave from the court, leave from the Honorable Court. An instant writ petition, being number WPA 22944 of 2022, was filed for self-same cause of action, my lord, with leave from the Honorable Court. I have annexed the impugned order and all orders of WPA 7832, MAT 219 and WPA 22944. They are around 30 in numbers, my lord. There have been 30 hearings. On 30th November, my lord, 2023, Honorable Justice Rajshekhar Mantha was pleased to order dismissal of writ petition for want of territorial jurisdiction, with liberty to approach Honorable Delhi High Court. My lord, operating portion I have given in para 3, because Delhi High Court is not mentioned in the operating portion. I have given the 2 things. Para 4, it is written, the order of compulsory retirement was passed at New Delhi. In para 14, it is written, the petitioner is at liberty to approach the appropriate High Court and or the court within whose territorial jurisdiction the order of compulsory retirement was passed. Means order of compulsory retirement has been taken as cause of action. So I was just bewildered because I have never worked in Delhi. There is no cause of action in Delhi as per my understanding.
No, the order of compulsory retirement was passed where?
In New Delhi.
In New Delhi.
In New Delhi. So all orders are passed at the seat of the government or the authority. All orders of NTPC is passed at New Delhi.
So who was your disciplinary authority?
The CMD.
CME means?
Chairman cum managing director.
That his seat is at Delhi.
He sits at Delhi and he passes all the orders.
So when was your ordered for compulsory retirement?
It was ordered, my lord, on 16 September 2020.
16 September 2020.
And the first hearing was done by my lord himself
No. Pardon?
First hearing was done by Your Honor only, my lord. First hearing was on 17/11/2020. It was by Your Honor only, my lord, as a single judge. At the time also, it was known that the order was passed in Delhi. It is page 10, my lord.
No, page 10 order was passed.
Hmm.
You challenged the compulsory retirement order.
Hmm.
I directed exchange of evidence.
Evidence, my lord. It was known at that time also, my lord, it is in the first paragraph itself that the order was passed in New Delhi. So had there been any want of jurisdiction, it would have been sent to New Delhi at that time only.
7832. The present petition is
Now, that writ petition was finally disposed of.
No, it was withdrawn by me and with the leave of the court, and another writ petition was filed for self-same cause of action.
Why did you withdraw?
Because, my lord, the affidavits are growing in size. Already 18 affidavits have been exchanged. And the main matter was just being lost. And hearing was not being taking place. So that's why I have appealed, and Honorable learned senior advocate in opposition agreed to that. May I go to that order, sir? Order. I'm going to that order. It is written there why it has been withdrawn. WBS 7832. It is in page 22. The petitioner appears in person.
So after 2 years, why did you withdraw the petition?
Because so many affidavits piled up, the original contention was getting lost, the original matter was getting lost, and I was not being able to get it heard. I was running from pillar to post, and I was not being able to get it heard. Originally, sir, originally, if we go to the original order, it was ordered that within 2 weeks it may be listed. And that was 2 years after I could not do anything. I was without salary. Now also I'm without salary. For no fault of mine, my performance is altogether outstanding. That can be seen from the documents. But only technical.
Your petition has been dismissed on territorial, on jurisdictional issue.
Jurisdictional issue.
So this compulsory retirement order was of September 2020.
2020.
That was, what were the charges against you?
Inefficiency.
Inefficiency, inefficiency, where you were working then?
I was working in Talche.
Pardon?
Not Talche, Jharsuguda, Dalipalli Super Thermal Power Project.
Odisha.
Odisha.
So, in respect of certain activities when you were working in Odisha?
No, my lord. It was done in respect of certain activities in Kolkata, when I was working in Kolkata.
When were you working in Kolkata?
In 2014, my lord.
Till
2014. And the activity was in 2000, unauthorized absence was the reason.
Unauthorized
Absence for 90 days.
When you were posted in Calcutta?
When I was posted in Calcutta. So for that, Honorable Justice Lapita Banerjee ordered some documents. Those documents were never supplied. Those orders were never complied. And that has been recorded also, my lord.
When he was posted in Calcutta, in regard to an allegation of unauthorized absence, proceeding was made. Then, now where was the proceeding conducted? Disciplinary proceeding was also conducted in Delhi.
No disciplinary proceeding was conducted, my lord. There's no disciplinary proceeding. Nothing. I directly called for an interview. And in the interview, just talked about the unauthorized absence. Because I told it was because of unauthorized absence. They said, okay, we'll look into this. And suddenly I got the order, my lord. With a show cause notice. I replied to the show cause notice. In fact, for the show cause notice, I had to come to the court itself. This court only ordered.
Now,
Giving the marks. I was not given the marks.
marks of what?
Marks of last 8 years. I was asked
So,
to.
Mr. Bhattacharya, can you explain? What
But
has
the lordship is well aware that there are systems in many organizations to not find out day rules. While his promotion was being considered like all others, then the authority found that he is inefficient. Therefore, he was directed to go on compulsory retirement. Not only alone, many others. Therefore, there was no question of any disciplinary inquiry on any ground of misconduct. This is a question of assessment of performance to be able to perform at the higher level.
under which rules?
Under the rules of the organization. There is no dispute to that. And he was assessed.
There was dispute, my lord.
But assessment was taken for 3 years, for all 4 years, for all the officers. And his case, it was 2015, 16, 17, 18, while he was posted in Jharsuguda. He is talking of that at 2014, he was on deputation in Damodar Valley Corporation. That has nothing to do with NTPC's performance. And ultimately, we have said that yes, you have a right to challenge before the appropriate forum. Ultimately, if the matter goes up, everything would be said at not saying this was beyond the territorial jurisdiction of the High Court, Calcutta. In fact, for his benefit, I think he should approach the appropriate High Court.
Now, is it a fact that the report was called for and no such report was filed?
Yes, my lord.
Every learned judge will not wanted to be satisfied that whether the TVC period was taken into consideration or not. We have given the detailed chart showing that we have considered for the year 15, 16, 17, 18, and he was on deputation in DVC in 2014. Therefore, that period was never under consideration.
The learned judge said that she was not satisfied, my lord. It is there, recorded. The learned judge said she was not satisfied by the document. I'm giving you, my lord, the page.
No, what is your problem if you go to Delhi and avoid this issue?
Delhi or Odisha, he can go to either High Court.
Order is about Delhi. So the problem is my averment. I have gone through the definition of given by the Supreme Court of the cause of action. It has to be taken from my averment or my ground, sole ground. It is recorded in the order.
Please try to understand. You have already been effected an order of compulsory retirement in 2020. We are in 2024. In the midst thereof, your writ petition which you filed, you withdrew, then you filed afresh, and the matter has proceeded for about 4 years. Now, today, good, bad, different, subject to what Mr. Bhattacharya says, if your period of consideration was a period which you spent not in Calcutta, then you might have some problem in coming to a conclusion as regards this matter. Try to understand.
I'm understanding. Then I'll submit.
Now, so far, if you are saying, suppose this issue has to be then decided, then this issue it has to be decided, it will take some time or it may not take some time. Then ultimately, if it goes in or against you, you have to go and approach the competent forum again. Now, if this is accepted, if the authorities accept this, that you can go and file there is no problem. Now, what is the problem here? You want relief from the court to go to the appropriate forum.
May I submit, my lord?
Yes.
Sir, firstly, learned senior advocate is making incorrect submissions. That is, it has been done because of the period at Odisha, which is not the fact. Fact is that it has been done.
First show us that any report which was called for was not submitted.
Yes, my lord.
Page 25. of the stay application, of your application.
25. No, my lord, not page 25. Just give me 1 minute, my lord. I'm just finding out the.
Yes, page 25, having considered, court directs a report on affidavit to be filed by the respondents. Page 25.
Page 25. Having considered the rival submissions, parties, the material placed on record, this court directs the report on affidavit to be filed by the respondent disclosing the note sheets that led.
This has not been done.
This has not been done, my lord.
This report has not been.
No, not been done.
Order, excuse me, Lord.
Orders are there, my lord. Please allow me to show the orders, my lord.
Oh,
all orders are here.
He is helping you.
No, he's not helping me, my lord. I know very well. He's not helping me. He's leading me to a trench. He wants to get me drowned, my lord. I know it. Sir, I know, my lord. So he's leading me to a trench. I know. I know him long, my lord. So please let me show the orders, my lord. The orders are here. All the orders are
He
here.
will go through the order first. Tell us this report was filed, yes or no.
It was not filed. It is written in these orders, my lord.
All right, very good. Not filed.
Not
Yes, Mr. Bhattacharya, you have not filed.
Kindly come to the order dated 19th of January 2023, page 27.
27.
Is filed. Yes, report has been filed.
Please see the next orders, my lord. Next order, my lord, page 28.
Yes.
However, inadvertent word annexure has been missing. In the circumstances, time to file an additional report on affidavit annexing the annexures to the note sheets is extended till February 6th. So they have not filed there. They have given an affidavit, but they have not given the documents. Without the documents.
No, by an order of 19th, this court directed 19th time to file an additional report annexing. Oh, this additional report was not filed.
No, it was not filed. And there was another order which was not filed, my lord. Then kindly allow me to find out the orders, my lord.
Mr. Bhattacharya, why can't you, why your junior may go through it? If these additional documents were not filed, you can show that to us.
The file will show it. So everything was done. We took this point of demurrer. Learned judge said, I shall go into that point. Let him be satisfied with the papers he wants. And we were proceeded like that.
Now this...
Kindly come to the order dated 1st of March.
It's not due to unauthorized absence. Unauthorized absence. So unauthorized absence only while working in Calcutta. So he cannot compare that. Compulsory retirement is not for unauthorized absence, for some other reason. So we have to see the order compulsory retirement. So in that, what is the ground? So that here inefficiency. So inefficiency from the period where
My lord, page 41.
It appears to be a case where Aurinda was at the end of his lives. And it shows that he wanted expeditious disposal, etc. Page 41.
Page 41, my lord.
What?
Third paragraph. Another set of document asked by this court. His honorable court, my lord. Page 41, third paragraph. This court requests Mr. Bhattacharya to produce necessary minutes of meeting showing the reasoning of PMC for reduction of the marks awarded by the reporting officer and reviewing officers 1 and 2, while assessment of the appraisal reports of 2015 as 16. Here it is written minor, it is because of the unauthorized absence. So this court asks for. Such records will be produced for perusal of the court. And the next order, my lord, it is said that those documents were not given. Instead, written instructions are handed over in court today regarding assessment of appraisal reports. However, this court cannot assess the issue with regard to the question whether the PMC, Performance Management Committee, while awarding the marks in appraisal reports of 2015 and 2016, took into consideration the period of deputation served by the petitioner in Damodar Valley Corporation DVC. So this document was not served, that this court could not decide the issue. And that is...
No, which document was not served?
PMC, the reports of PMC for 2015 and 2016.
No, the page 41, it was the meeting, minutes of the meeting showing reasoning of PMC.
Reasoning of minutes of meeting of PMC.
So that was furnished by way of a written instruction.
No, that was not furnished.
Page
That is why I think this court cannot assess. It was not furnished, my lord. The documents can be seen. It was not furnished. Though the order is not that clear, but that is written in the next order, my lord. Next order, it is very clearly written, my lord.
Wait.
In next order, my lord, it is very clearly written. 1 minute, my lord, just. I'll just come to the next order, my lord.
You had an advocate.
I had so many advocates, my lord, but I could not do anything. Here it is written, my lord, page 45. It is written here. Mr. Deborman, learned counsel appearing on behalf of the petitioner applicant, submits that the order dated January 25, 23 and June 7, 2020.
That is your submission.
Submission. But it was not, when it was accepted, it was not objected to. But
sir, what document do you want?
These documents which have been ordered.
Which document?
So, first is annexure to the note sheets.
Annexure?
To the note sheets which led to the abrupt termination.
Where is that you have said?
That order. It is in January 25th.
That is page 41. Court requested Mr. Bhattacharjee.
That is June 7 order.
Yes.
And January 25, 2023 order is there.
January
25, 2023, page 28, my lord.
This additional report which you are saying, this additional report was filed.
But without the annexures, my lord. Report was filed, but without the annexures, the order. Affidavit annexing the annexures. They are filing the same document.
How that reports are helping you?
In that report, it is written why I have been given. It is written because of unauthorized absence. It is written there. That's why they are suppressing those documents.
So where is the order of compulsory retirement?
Order of compulsory retirement, it is here, my lord. Page number. It is page number 9. Order of compulsory return.
Where is the writ file?
Huh?
It a writ file ta call for koreche. In the writ file, we will call for the writ file on whatever documents are there.
Yes. With deepest of respect, my lord, Lordship, excuse me, all these are on the question of merit of the matter. We wanted the learned court to decide.
We want to see only that the compulsory retirement in which the period of assessment, as you said, that was from 15 to 16.
Yes, that report was filed before the Honorable Court.
Mr. Bhattacharjee, please assist us. We are bringing the writ file.
My lord.
You show us that issue,
Yes,
then
yes.
we will hear his submission.
Yes, my lord. I was obliged, my lord. Very much obliged.
এটা রিট ফাইলটাকে তুমি কল ফর করে নাও।
আজকে ফাইল নেই তো।
Heard the appellant appearing in person and Mr. Bhattacharjee, learned senior advocate, appearing for NTPC Limited. Please the matter for further consideration in the daily supplementary list of this court on 11th. On 11th January. Stop. এটাতে কি অর্ডার করতে হবে রিট ফাইল রিকুইজিশন করতে দরকার তাহলে ওইটা রিট ফাইলটা রিকুইজিশন করে আনিয়ে নাও।
May not be 11th. Can you excuse me? Will just check me.
Yes.
11th, I may be out of station.
10th?
Yeah, my thumb is
10th, Mr.
10th.
10th, you will be all right.
Hopefully. Yes, just give me 1 second. No, 11th, okay. 11th, all right.
11th, all right.
At 12th, I am busy.
Obliged, my lord.
Always. This person is not a chamber junior. Please not. Not like yes. So in that we will consider, you also consider the tribunal is supposed to stay the order of transfer and it is nothing remains to be decided. We will say don't take any penalty. Because they will immediately issue a show cause that you got
My lord, for the respondent, Ms. Sushmita Shahadatta is appearing, my lord. She is now appearing before Honorable Chief Judge.
What is this matter?
Your Lordship, this is
It
regarding.
is which we heard earlier.
Yes, Your Lordship. They were to, this is regarding the recruitment, selection, and appointment of the
No,
petitioners.
there were 16 matters.
No, that is a separate matter, Your Lordship. This is regarding the appointment
This
of
has
a.
come up first time before
No,
us.
for the third or fourth time, Your Lordship. Your Lordship had directed the respondent to bring few documents.
Yes.
Which shows that the bona fide right of the petitioner is not accepted by them. He wanted the selection, he wanted the appointment, Your Lordship, in which he was selected. His
What is
attestation
the
form was
subject matter? What is
subject matter is regarding the appointment of the petitioner as machinist in Dum Ordnance Factory, Your Lordship, under the Ordnance Factory Board.
appointment?
Appointment, Your
So
Lordship.
appointment was not given, agreed thereby you approach the writ court.
Yes, Your Lord. First, I approached the Central Administrative Tribunal. Two posts of the subsequent selection process was kept vacant for them till 2018, Your Lordship. They vitiated the entire selection procedure when it was
Then
concluded.
how did you come to High Court?
Yes, Your Lordship. We had preferred a review application because first time it was dismissed by the division bench in High Court. First, we moved the WPCT 1 and 2 in the year 2018, Your Lordship. It was dismissed. We preferred a review. A review was allowed and it was, the order was set aside. So now it is for consideration at the final stage of hearing, Your Lordship.
Yes, where is your
I am praying for short password, my lord. Ms. Sushmita Shahadatta is appearing before Honorable
Who is
Chief Justice.
appearing?
Ms. Sushmita Shahadatta.
What do you say? We keep it tomorrow.
Your Lordship, today, Your Lordship, after some time, if a short passover,
Try your luck.
because
We don't know. We have fixed matters also.
because
Yes.
they are just avoiding this hearing, Your Lordship, for the last 10 years.
Start with what you say. Yes, you.
After starting, if they are not able to come.
List of dates and everything has been.
The matters. No? Everything.
We are ready.
Yes, Your Lordship. I have to submit few decisions of the Honorable Supreme Court and High Court, and they have to submit if any documents are there with them.
You, as regards the factual issues, you have already argued.
Yes, Your Lordship.
Thank you. All right, call her. Ask her to come. Password put it.
Obliged, Your Lordship.
I am for the petitioner. Lordship, I am appealing for the state respondents, Lordship. Lordship, yesterday, Lordship's pleasure was that whether the petitioner can be given appointment in somewhere else because Kashipur police station is not existing. So, Lordship, here is my report. The Amita Nahar has been posted to Kultali PS in cancellation of her earlier posting order at Kashipur police station. Lordship, here is my report.
Kultoli is where?
Kultali is in South Chobbish Pargana, Lordship.
Very good, Mr. Roy.
Subject to your question, but kindly come to page.
Your purpose has been served.
But kindly come to page 38. There is a page 38 of the page. Page 30.
38.
Well, 38.
Hmm.
This is the transfer policy I have annexed. Okay. Next.
No, Mr. Roy, have you availed, you do not want to go and join in Kultoli?
No, but what happened? This circular says that if
any officers like my constable or assistant inspector police serve 15 years of service, serve 15 years, then they are entitled to be transferred to his hometown. It is there, but I have annexed these documents.
Yes, go and join there and make the
After that,
representation.
কুলতলি কোথায়? কুলতলি এটি সাউথ চব্বিশ পরগনাতে। আপনারা তো সাউথ চব্বিশ পরগনাতে আগে পোস্টিং করেছেন।
Nothing remains to be. This will be nearby to your place where you are residing.
I am, what happened, my mother is now suffering from cancer.
Where
So
are
court,
you residing?
Jadavpur, I am now Jadavpur, residing Jadavpur in police quarter. What has been
যাদবপুর
allocated
is in
to?
সাউথ চব্বিশ পরগনা লর্ডশিপ।
Kultoli is in South Chobbish Pargana.
Yes, yes, this
What
is
is your problem?
No, no, I have not, madam, kindly.
Very good.
I have not, because what, I paid subject loss of correction. I made representation on 28 August 2023 before the Suvarna Police that giving 3 places that since there is no existence of Kashmir police station, he
What,
can.
Mr. Rai, what remains in this petition? They have cancelled your
Yes,
transfer
my
order
lord, I am not on
and
that.
they have posted you in a different place.
My lord.
You go and join the different place,
My lord,
regularize your pay scale,
my lord,
and thereafter you make representation that in view of such ailments you approach me here.
my lordship. But this observation, if your lordship kindly.
What is the distance standing to Kultali?
She is not in Delhi.
What's the distance to Kasipur?
Kultoli.
Canning, she was working in Canning.
Canning.
And Kasipur.
Canning also she was dissatisfied. He is resident of
চব্বিশ পরগনাতেই আছে কুলতলি, খুব বেশি দূরে না, ক্যানিং এর।
Kultoli is where?
It's in সাউথ চব্বিশ পরগনা লর্ডশিপ।
Big.
আচ্ছা।
Then you come with an you talk with your client and tell us.
Yes, ma'am.
You give a copy of this to
Lordship,
Mr.
ma'am,
Rai.
that will be better, ma'am. Since the lady my lord is suffering and his young children is there for school going, my lord, but I will come with the instruction. my lord.
Lordship, it is a transferable job.
You
She
do
has.
one thing, you give a copy to Mr.
Lordship,
Rai.
I have already given.
You take instruction and come back. Yes.
It's a transferable
When can you
job.
come?
Tuesday, my lord, because Monday.
10th. Yes, 10th.
Ma'am.
You have given a copy.
Lordship, I have given. I have got.
দুজনে বলবো না আগে যখন
Well,
Sir, I'm the respondent number 1 and 2.
who is for the petitioner?
Union of India. কেউ তো নেই।
No, those are.
10, 12
You are for the respondent.
Respondent number 1 and 2.
Who is for the petitioner? Nobody is here.
Lordship, actually, the non-appearance approach of the appellants is continuing last 13 years. This case is pending before your lordship.
Your Lordship, we are for the added respondents in CAN application number 12 of 2022. Your Lordship, this matter was taken up at least for 4 times in last one month. And on all occasions, the Union of India has taken adjournment.
Have you complied with your earlier order?
Mr. Kumarjit Theory is appealing for the appellant, man. He's on his leg, man. Praying for short Passover.
This is happening for the last 4 days, Your Lordship.
Man, he's on his leg.
Yes, tell us what is the matter. You are for whom?
I am for respondent 1 and 2.
Respondent 1 is, who is respondent 1?
Respondent 1 is Central Board for Workers Education Officers Association.
Yes.
And Mr. Aditya Bhattacharya is respondent number 2.
Malad, me.
What?
Malad, Malad, there is a CAN application 12 of 2022. I am being led by Mr. Kallol Bose. Malad, this application is pending for consideration for the last 1.5 years. Malad, if they do not want to argue the matter, it is up to them. But my application is pending. Probably this
your application.
CAN 12 of 2022.
It was disposed of.
No.
No, there was a problem in the CIS system that my lord has rectified it. This is an app. The original respondents are getting the benefits of the order. I have retired in the meantime. I am also seeking the same benefit. Nobody will be prejudiced.
Have you checked up this, Mr. Pure?
Milord, kindly see, Milord, the order dated, Milord, 12th of August, Milord, 2022. Milord, it is in respect of Can 12 of 2022.
No. That was in respect of an addition of party application. They had consented to. We didn't file an application. On their consent, it was allowed.
Yes,
Party.
addition of party application was allowed.
This is a separate application.
Can 12.
Can 12 stands on a different footing.
It is there in Can 12.
No.
Order sheet দেখ না।
আরে বাবা হ্যাঁ Can 12 এর সেইটা Can 12 dispose of হয়নি। Can 12 is on a different footing. My lord, kindly seize the prayer in Can 12.
What is the prayer?
Prayer, my lord. I am
addition of party prayer A.
No.
Applicants be added as party to the petition.
My lord, that is one prayer. The second prayer, my lord, for a direction on the implementing authority to apply the administrative order dated 28/5/2008. My lord, this is the primary. The A part has been complied with.
Well, what my learned friend is saying, Milord, subject to correction, Milord, kindly see the order passed by the division bench. May I just place the order?
Which order?
The order dated, Milord, 12th of August 2022. Well, just may I place it?
12th of August?
2022.
Yes.
It is, Milord, in respect of, Milord, Can 12 of 2022. Milord, kindly see, Milord, this is an application at the behest of the several retired employees seeking their addition with composite prayer for extending the benefit of the circular dated 28th of May 2008. It is submitted by Mr. Basu, learned advocate, appearing on behalf for the applicants, that the coordinated benches have been passed directions for extending such benefit, and therefore there is no fetter on the part of this bench in extending the same benefit as extended to other retired employees. Learned advocate for the Union of India submits that if the prayer for extending the said benefit is allowed, that would create a burden on the exchequer, and therefore the prayer should not be allowed at this stage. However, she says that there is no objection on behalf of the petitioners if the applicants are added as party in the instant writ petition. In view of the above, the prayer for addition is allowed. Let the applicants be implemented as party respondent in the instant writ petition. Office is directed to amend the cause title. And next, so far as prayer for extending the benefit of the circular dated May 28, 2008 is concerned, since the main writ petition is pending and the core issue is integrally related, the aforesaid claim, we feel the aforesaid prayer made in the writ petitions be considered along with the writ petitions. Now, both the points are taken into consideration by the division bench. How my learned friend is saying, that addition of party issue was considered, and so far as 28th May 2008 circular was not considered. In my reading of understanding, both the issues were considered. And
let us hear the main matter.
yes. Well, kindly, fix a date, here of the. No, but I can proceed with the matter. I can proceed.
My lord,
Here,
actually, main writ petition has not been heard a single time.
pardon?
Main writ petition, actually, it not have been heard till date. A single hearing has
Which
been.
main writ petition?
That is, 85 of 2001.
So we are hearing now.
No, sir, this is actually, so far it is going on for the Can applications.
No. Can application, his prayer was that addition of party has been allowed, but my prayer for the benefits which I prayed for in prayer B, that has not been considered. So my application has not been disposed of. But from the order, it appears that argument was taken into consideration, and the court said we will consider his prayer at the time of final hearing of the writ petition. So we are hearing the main writ petition.
Actually, respondent number 1 and 2 have not yet been actually permitted to submit its reply affidavit. Opposition.
Opposition to what?
Reply of the writ petition.
Opposition to the writ petition.
Now, after 2010.
No, sir.
That's why I'm seeking your permission.
What formation? What affidavit have you ever prayed for affidavit?
That's so long that
Where is the impugned order?
Impugned order, my lord, is appearing at page 77 of
That
the my
is
lord,
of this impugned order is of 2007.
2007. 27th of September 2007.
So this was filed by the respondent number 1.
Yes.
What was the issue?
Issue is, my lord, that these respondent number 1, they are the
What did they claim in the petition?
they are claiming for enhanced pay scale. My lord, before the promulgation of my lord, second pay commission, they used to get the salary at the same salary of the grade 1 of government officers. Now, my lord, after the promulgation of my lord, second pay commission, their salary was reduced and that was at par with the other government undertakings. Well, it is basically a society and is a government of India undertaking. So, well, they were getting the salary at par with the other government undertakings, well, in view of the recommendation made by the third, fourth, fifth pay commission. Now, well, they challenge it by saying that previously you were on better footing, now you are on worse footing, as because we used to get the salary more than the A grade gazetted officer. Now we are getting the salary less than that. So, well, tribunal has passed an order, my lord, directing that anomaly committee's recommendation should be considered by the government, and on the basis of that, challenging that Union of India has filed this writ petition.
Mr. Tiwari, you have been asked to consider.
No, Milord,
Kindly
now, Milord, on the
page 84, kindly come. Page 84
Yes.
of the order. Kindly see the operative portion. This cannot prejudice you in any manner. Unnecessarily matter is dragging for so many years.
now, Milord, what happened, Milord? Under the guise of now, Milord, when this order was passed and subsequently this Hon'ble court, Milord, from time to time passed several orders. Now, Milord, a contempt application was filed before this Hon'ble court, and Milord, another threat of contempt was something else, Milord. A notification was issued by the government of India, Milord. That notification, Milord, your lordship would get it, Milord. Your lordship, Milord, kindly takes, Milord, my writ petition. In that notification, it was provided that benefits to be given. Well, kindly take, Milord, can 12. Milord, it is also annexed in
Tell us, you are not ready with the matter.
I am the ready, madam.
Then
Sir,
what
sir,
is
landed-
your prayer?
My
What
my
opposition you want to use?
actually, sir, the honorable tribunal's order was
We are
partly.
We are not on that. We are wanting to know why you want to file opposition to what?
To some, actually, whatever the stand taken by the Union of India, I have the proper justification to show the court that their submissions are actually not based on the facts, sir.
After 14 years, what new point?
No,
you will take?
nothing, sir. Actually, they have partly implemented the order of the Honorable CAT.
They have totally implemented.
They have totally implemented without considering.
Kindly takes up my CAN application, that order is annexed.
এটা কোথায়? Tagger গুলো দাও না।
This order of the tribunal is already implemented.
There is a right. Scale has already been given.
There is a rider. Rider is
other benefits they are not given despite of the Honorable Discourse order.
Kindly
Now,
takes up
subject to result of
page
the petition.
32 of my CAN application.
yes, Milord.
Kindly takes
Page
up.
32 of can 12.
CAN 12. Kindly takes up.
Page 32.
32 of my CAN application, CAN 12 of 2022. After this, my lord, probably nothing more remains. Subject to correction from my.
Yes, what is this order?
My lords, kindly see removal of anomaly for the cadre of education officers, implementation of Honorable CAT Calcutta benches order dated 27/9/2007 in OA number such and such, such and such. In compliance of the order, this is the order under challenge in WPST 85 of 2020, 10, passed by the division bench of the Honorable Central.
How that? 27 September 2007. Where is that order?
That is the impugned order in
77.
That is
page
77.
It's order of the division bench of Central
Central Administrative.
Achha, in compliance, yes, read.
in OA number such and such in the matter of Officers Union of India and other as per approval of Government of India, Ministry of Labour and Employment, New Delhi, contained in their letter number such and such dated 28/5/2008, the cadre of education officers from education officer to additional director has been given the following pay scales with effect from 1/1/1996 on the notional basis, with actual payments being made from 9/7/2007. My lord, this is then there is a chart showing the revised scale. My lord, kindly turns over to the next page. There is a rider here. The overpayment, if any, detected later, will be adjusted from any amount due. An undertaking will be obtained from the officers in writing while making the payment of arrears of salary to the effect that any excess payment that may be found to have been made as a result of fixation of pay may be refunded to them to the CBWB either by adjustment of such and such. My lord, this is not relevant, my lord. In terms of this circular, they give effect to the TRICAT's order. Thereafter, this is in 2008. Thereafter, in 2010, they filed this appeal,
just
challenging the order of 2007 of CAT.
Just to linger in the
sir, please.
Then what happened?
My lord, thereafter, in the meantime, from 2010 to 2024, my lord, several officers have a bunch of officers have retired. They have filed applications before this honorable court, before honorable high courts of all over India. Because since this is a parent application, parent petition is pending before this honorable court, all the honorable high courts in India, I have orders, my lord, from Madhya Pradesh High Court, Delhi High Court, where they have given the benefit to the subsequently retired officers based on this circular, stating that since the main matter is pending, we direct that the respondent Union of India shall give effect to this order, subject to the pendency of this writ application. My lord, I will supply those orders, my lord. Even this honorable court, in the meantime, my lord, kindly finds there is an order dated 17th of December 2013. My lord Justice Pranab Chattopadhyay, sitting with my lord Justice Samapti Chatterjee, had passed a similar order.
17th
of December 2013. May I hand up my?
Wait. 17th of December.
No, yes. Ek minute. 17th of December 2013. My lord, my lord, kindly sees, kindly goes to my
This application 4818 is the which application? That is different application.
Yes. This has been disposed of, my lord.
This application is final.
My lord, the third.
Your application is subsequently.
My lord, I have retired later on. We have retired, not I. We have retired.
এটাই তো মেন
This order was not complied with.
No, they have given effect to. Those, the applicants in that application are enjoying the order.
Very good. Now you are saying that
another order, my lord, kindly, another order. 7th of September.
No, this was an application of 2013.
My lord.
You have subsequently
Retired. I have come.
want the similar benefits as
And,
given.
my lord, my lord. My lord, another application.
What?
Another order, my lord. 7th of September 2012. This Honorable High Court grants same relief to those
7th of
September 2012. My Lord Justice Nishita Matre and my Lord Justice Roy Saraswati, Anindita Roy Saraswati, my Lord, they have passed a similar order.
7th of September 2012.
12. My Lord, may I hand up?
No.
Okay.
কোথায় পাবো বলো? Got it here?
17, the back side.
All crumpled together. This is 12.
Not the person.
Hey, give us the order.
My Lord, my Lord will kindly excuse me. I have marked the relevant portion. My Lord will excuse me.
এত কি বড় দিস? You don't have a ফেরত দিয়ে দাও। এখান থেকে বের করো তো 7th of September
7 September 2012.
Now, why you are showing us the other order?
My Lord, why I am showing this?
When was this order of Justice Pranab Chattopadhyay was 2013?
13.
Why
Before
you
all-
are showing
My Lord,
2012?
I stand on the same footing.
Which one?
The
Why you are showing us this order? How does this order help you? This
because I also stand on the same footing. I also need the same benefit.
But already the division bench held that your application will be taken up along with the main writ petitions.
My Lord, but that is not being taken place, my Lord.
No, Mr.
Main writ petition will be taken up now. See, earlier in the year 2012 and 2013, they have granted relief.
My Lord.
But in your case, that was not considered. Instead of that, you were impleaded as party respondent, and it was held that your application, your request will be considered along with main writ petition.
My Lord.
Therefore, now you cannot rely on 2012 and 13 order and ask for the relief sought for in the your CAN application. Therefore, you wait for decision in the main writ petition and get order.
My Lord, the whole difficulty is we are
The whole difficulty, you did not challenge it at that time.
My Lord,
When you retired,
my Lord.
when this order was passed, last order which was passed on court directed that your second prayer we will consider at the time of final hearing. Why were you silent there?
My Lord, no, my Lord. What had happened was, my Lord Justice Tandon's desire was,
We don't understand when the court says we will hear your contention at the time of final hearing, then you keep quiet before the trial.
because it was fixed on just a week after.
Yes,
Thereafter it
you
was
were
not-
silent before the other division bench, and now you are struggling to obtain the order just now.
No, my Lord, no. My Lord will not take me amiss, my Lord.
No, it is not a question of amiss. Have you understood what
My
my
lord, my
sister?
lord, my lord.
Then why you are jumping? You have lost that opportunity already. You cannot ask us that you decide my application relating identical relief just now. Because you were silent before Honorable Justice Horish Tandon sitting with Justice Shampapal. At that time, you did not open your mouth. That don't keep it for final hearing. We are covered by similar order. Why should we not get that order? You were silent.
No, my-
You were silent.
No.
You were there.
Yes, my Lord. My Lord, what was
So
happening?
that is because we grant you leverage. We ask you, sir, what is your problem? Don't get sad. Tell us what is the matter. And other benches, you sit quiet in your table. You don't raise your voice.
Can we
Just to
recall
show.
that earlier order? No. Can we recall that earlier
Now,
order?
Mr. Tiwari, tell us. You have substantially complied with the order. What remains in the writ?
Others are there.
What others are there?
Well, two things well, I will canvas to your lordship. Well, absolutely on merit. Well, I have given
It is still they are interested.
Mr. Tiwari, what we ask you is, seriously, if you want to, because this order, We know your limitations. We understand your limitations. You cannot concede on behalf of union. But we are asking, what is the use of dragging the matter when your government itself has issued a notification?
May I submit one thing? Give me 7 days time. Let me consult with ASG and higher officials. Then let me come back before you. Give me 7 days, 10 days time, Milord. I know, Milord. 28th of May 2008. But only two things, Milord, I will be. Only two things, Milord, I will be conversing before your lordship, Milord, whether Central Administrative Tribunal, Milord, Kolkata bench had jurisdiction to decide the issue. Number one.
You decided. You passed the order.
No, Milord, 20. This is 20th of May 2008. This circular that is appearing at page 85. This said, Milord, this payment was made, Milord, subject to recovery.
Order 2007, 2008 you complied the order. Then after 2 years of compliance, you filed a writ petition and tracking the matter for 14 years. And now whether from 2008 you are complying the order, granting the relief to all retired employees. And now what is there to
only one thing, Milord. In 2008, Milord, compliance, it was stated, Milord, the overpayment, if any, detected later.
You are not interfering with them. You do overpayment. Recover everything.
Milord, that is, Milord, in compliance with the order under challenge.
Order passed in the future writ petition.
Yes.
That time also you have not filed any writ petition.
No, that was not filed, Milord. This order was passed, Milord, on 2008.
There is no rider clause that is subject to result of the matter to be decided against the order dated so and so. There is no such clause.
It is stated, Milord, in compliance with the order passed by the tribunal.
They can do. What is your problem? We are not interfering with that clause.
Milord, may I? Give me 7 days time, Milord, may I come?
The council straight away we can say already order of the tribunal is complied with in the year 2008 and nothing survives now and we can straight away we can dismiss this.
No, Milord, even if, Milord, even if, subject to your lordship's kind of approval, even if, Milord, after the compliance of the order passed, if I, Milord, challenge the order of the tribunal, and if I can succeed in the order in the writ petition, then, Milord, everything can be done, Milord, everything can be undo itself.
You cannot. See, this was complied with in compliance of the earlier order.
This is an argument on desperation, Mr.
Milord, give me 7 days time, Milord, I will come back. I can understand this, Milord, give me.
We will only record that by this order, you yourself have stated that you have complied.
Not only that, Milord, subsequently several orders passed by the Hon'ble Court that was complied with. Milord, I know my limitations, Milord. I will come back 7 days after. Milord, kindly give me 7 days.
My lord.
It will be to be mentioned.
Yes.
on 10th.
Keep it to be mentioned.
On 10th, as to be mentioned, it will be there. We will dispose of.
Yes.
My lord, may I permit to say one thing? Actually, they have partly implemented, given the salary, but other benefits they have kept hold.
Go to the tribunal and
No,
file.
sir, it is in the order, sir. It is in the order, but they are not complying with.
For that, you have other remedies, sir. For that, try to understand. Let them get the benefit in terms of that order.
Milord,
if you have any further grievance, you go and approach the approach.
Milord, I am led by an additional Solicitor General. Most probably, he is not in a position to connect.
We are not passing any order. We are only keeping it as এটাকে first matter করে দিই, হ্যাঁ? Okay, to be mentioned orders বলে উপরে লিখে 10th করে দিই।
10th.
Orders 10th.
Comply করেছে
Can applicants, one of the can applicants.
We will dispose of.
Everything
Not dispose. My can applicants.
Yes.
Three of the can applicants have been diagnosed with stage 3 cancer. They are in the chamber of their life.
Diagnosed?
Diagnosed with stage 3 cancer.
So what did you do before the other coordinate bench?
They had
What did you do? Tell us.
They were seeking.
Since the court is strict, you keep quiet there.
My learned
You
friend
don't
is
open your mouth.
crossing the limit. But his prayer was rejected by the other division bench. Despite that, he is arguing this thing. I will be coming on 10th.
We are not on adversarial litigation.
No, absolutely. I am also not. Milord. I am also not on adversarial litigation. Otherwise, I would not have considered.
Write to them that
yes.
already you have complied with And without
That's why, my lord, as because I am appearing for the government, my lord,
A letter from the ministry finished.
finish. I'll try for that. My lord.
written instruction and withdraw the writ
Yes,
petition.
yes. I'll do that.
But don't take any adjournment on that day, Mr. Tiwari.
I'll not. I'll not.
Then you have to get
You
instructions.
you get it finished, we will finish it.
Yes.
My lord, they,
Otherwise,
whatever
I'll-
they are pleading, sir, it is not in the actually fact.
क्या बुझो কি বোঝাবে? What will make them
স্যার হয়ে গেছে আপনার হয়ে গেছে চলুন ডিপলি অবলাইজ মিনিট 10 তারিখে হয়ে যাবে
হয়ে যাবে তো
চলো ইয়েটা লিখে দাও, একটা জাজমেন্ট আছে না,
1 o'clock.
ওইটাই লিখে দাও, অর্ডারটা দিয়ে দিই। হ্যাঁ হ্যাঁ Give them come to me before we pass the order. Very difficult also. I'm really being frustrated. No.
Your Lordship, the petitioners were selected as fitter mechanic in the post of reserved candidates, which was published in 2010 by the Ordnance Factory Board, Damdam. Factory was Damdam, in which the recruitment process was initiated. Your Lordship, the attestation form was issued and all formalities were done, and he was selected. His merit position was third. But later on, appointment letter was not issued for a very long time. So he made RTI applications successively for 3 times and also made representations in which he got the reply from the Ordnance Factory that the entire process,
Are we hearing the matter finally?
it has been heard, Your Lordship, but Honorable Justice Partha Sarathy Chatterjee was there on the last occasion when the matter was heard. So
Very good, but we are hearing the matter. Any paper books have been filed?
no, your
All
lordship.
the pleadings are on record.
Yes, all on
Pleadings
record.
are on
Yes,
record.
yes.
Yes, have you seen those? All the pleadings are on record.
My lord. Review was preferred, your
Because the
lordship.
review was filed, my lord, review was heard at my lord, and thereafter
The order was passed,
order was passed.
encompassing all.
Justice Partho Chatterjee, I heard.
Yes, my lord.
Yes, your lordship.
All right, then we keep it next week. Maybe that bench may be constituted next week.
My lord, as your lordship's direct.
So your
We
lordship.
also do not know, because if now my sister has to hear, it has to be from the beginning, it has to be heard.
Yes,
You have to again re-argue the matter.
yes.
You wait for this week. Let us see if
Yes.
it is not before Justice Chakraborty. Then when we sit with my sister, we shall take it up.
My lord.
On the your lordship, I will
We are
wait.
not sending it out of list. It will be in the list. Let us see how the list, not this week, put it up.
Obliged, your lordship.
Take it out from the-
Deeply obliged, my lord.
Lordship, I am for the appellant. My lord was pleased to hear me in details on previous occasion. Only one thing, my lord, I want to highlight is this. Lordship has not yet prepared the judgment. So, my lord, I want to seek a time to file my written notes of argument. Lordship allows me.
We are passing.
But in that case, my lord, I
My lord,
only want to
argument has
highlight.
been concluded.
Yes,
My lord,
yes.
argument has been concluded.
Because the copies are voluminous in nature. That is the reason, my lord, I was thinking that if I can highlight some of the relevant points for your lord.
Dictating, you
Now,
listen.
only one thing, my lord. Before lordship delivers an order, there is a office notice where it has been countersigned by the additional CMS, Southeastern Railway, saying that I have worked from April 2014 to
Not
July.
in the paper book. Not in the paper
Just a
book.
minute.
My lord,
Wait, no, sir. If we can have the patience, why can't we? Are sitting from 10:30. We are having the patience, sir. Why don't you?
My lord,
His matter, it is the last court. It
Yes,
is
because-
the last court. We will not
No,
allow.
my lord,
Usually we do not act in such manner. We don't know. About us, we know. We usually do not shut down any person. If he has said, all right, very good.
only one thing, my lord. This is an office letter of 2015 issued by the additional CMS AC Railway Kharagpur, stating that the payment is outstanding so far as my service is concerned from 2014 April till July 2015. So these months I have worked that they have endorsed it, and they have sent these bills to the respective offices, but I have not received yet. So lordship delivers any order, lordship, kindly consider this aspect.
You didn't agitate that when the writ petition was heard.
My lord,
Where is your argument to that effect before Justice Bhattacharya?
my lord,
This has subsequently come into your hand.
Yes, my lord, this is a office note, that is, they have accepted that I have worked for 106 months. So that payment is due. That has been considered. That is their letter. I am not asking anything. I am not
Mr. Roy, that
if that be because lordship kindly realize one thing, my lord, lordship is very considerate. Lordship, I am 68 years old. I am financially handicapped, my lord.
be happy with your quarter and your dispenser. You have dug your own grave. You ought not to have. Kindly come to page 168. You have dug your own grave. We want to help you, but we cannot.
Well, some
Kindly come to page 168. Your withdrawal of suit order. See what you have stated. That is, no, not 168. That is, yes. That is page 200 and, yes, 248. See what you have said.
Yes,
Third
because
line, after passing of the order, the defendants have reinstated the plaintiff to his previous position and has regularized possession. Accordingly, all the grievances of the plaintiff concerning the instant suit has been mitigated.
because my lord, may I say one thing? The prayers in the suit were for
Yeah, now kindly come to the prayer in the suit.
now, my lord, except the salary part, all benefits have been restored to me. Now that
What-
was my
what-
contention.
Kindly come to your suit, Mr. Rai.
Suit is of 2015, my lord. Lot of water has gone.
Regular salary entitled to live in the quarter. Both of them were there.
Entitlement, my lord. But after Honorable High Court has passed an order, these all facilities have been regularized by these. Lordship kindly balances so that at least something I can get, my lord. I understand, my lord, what is passing through your lordship's mind. I will not say anything.
Come with a better case, Mr. Rai. We have given you opportunity.
Only thing, my lord, I am
এই দেখো, তো আমাদের শরীর খারাপ করে দেবে। The present writ petition has been preferred, challenging an order dated 5th of April 2022, passed in a writ petition being WPA 1788 of 2020. Mr. Royal Learned Advocate appearing for the appellant stroke writ petitioner submits that the learned single judge are in law in arriving at a finding that the service of the appellant was not protected by any statutory provision, being oblivious of the fact that the appellant was appointed under a scheme regulated by the Railway Board circulars and financed by the Staff Benefit Fund bracketed in short SBF bracket close committee presided over by the Chief Personnel Officer and its office bearers, Chief Personnel Officer and the office bearers of the said committee are all officers of the railways. Stop. Drawing our attention to clause 4 of the next better. To clause 4 of the appointment letter dated 24th October 1979, Mr. Roy argues that prior notice to that prior to alleged termination, the authorities did not serve the notice as mandatorily required under the said clause, and instead by a memo dated 24th of May 2016 issued by the respondent number 6 hearing, it was informed that the appellant service quote unquote deemed to be terminated with effect from 01.04 stop 2014 এই পেজ 195 ওই পোর্শনটা আছে যেটা তুমি italics এ দিলে আর কি সিঙ্গেল italics এটা করে stop. The appellant was engaged as a homeopathic practitioner to work for 8 years per day. 8 hours per day in the dispensary. Such appointment, according to Mr. Roy, was a full-time appointment, as would be explicit from clause 3 of the letter dated 24th October 1979. Stop. 24th October, October. Stop. Such issues, as urged, were glossed over by the learned single judge, and no specific finding was returned on the same. Stop. Such infirmity warrants interference of this court. Stop. Mr. Roy further contends that the respondents illegally stopped the appellant's salaries with effect from 1st April 2014 and initiated a proceeding under the Public Premises bracket A Eviction of Unauthorized Occupants bracket close Act, 1971 bracket A, in short, the 1971 Act bracket close, to evict the appellant from the quarter and dispensary. In the said proceeding, the order of eviction was passed on 2nd July 2017. Even after arriving at a finding that there was no, even after arriving at a finding that the even after arriving at a finding that there was no legal termination of the appellant's service. Stop. Aggrieved thereby, the appellant preferred a revision application which was disposed of by an order dated 28th November 2018, setting aside the eviction order. Stop. The said order was thereafter complied with by the respondents, and the appellant is still occupying his quarter and is running the dispensary, as would be explicit from the document annexed at page 257, annexed at page 257 of the paper. Stop. Such rendition of service also stands admitted by the appellants, by the respondents. Stop. In the said conspectus, the learned single judge erred in law in dismissing the writ petition. Stop. Mr. Mukherjee, learned advocates appearing for the respondents, denies and disputes the contention of the appellant and submits the appellant was appointed by the SBF committee temporarily. Stop. Such engagement was subject to renewal every year. Stop. The appellant's appointment was discontinued by the said committee on and from 1st of April 2014. Stop. Such act of the said committee was in consonance with the Railway Board circular dated 2nd July 2003. Stop. He further argues that the appellant earlier filed a title suit being TS 421 of 2015 for a declaration that he is still in service and is entitled to get his regular service. Stop. However, the appellant himself withdrew the said suit. Stating inter alia that, quote unquote, after passing of the order the defendants have reinstated the plaintiff to his previous position and has bullet that and has regularized possession in the quarters. Stop. Drawing our attention to a memo dated 26th March 2013. Huh? Date of the order.
This memo date. Memo date is
Which memo date? This is the petition. The petition for withdrawal. Clearly drawing our attention.
Memo dated 26 March 2013.
Okay, drawing our attention to the memo dated, এটা কি হলো দেখো তো? ও এটা বন্ধ হয়ে যাচ্ছে। F1 করতে হবে। এটা কি আসছে? Drawing our attention to a memo dated 26 March 2013, Mr. Mukherjee submits that the petitioner was duly informed that all the facilities available to him had already been withdrawn. Stop. The said memo was not disclosed by the appellant in the writ petition. What's it? I kept the points in the laptop.
We'll conclude. You can tell the result of the case and we'll tell. It's time now. So petition we'll say the result that petition dismissed.
Next one. Indisputably, the petitioner the writ petition was preferred by the petitioner primarily for disbursement of his salaries from 1st of April 2014. There was no substantive prayer towards restoration or reinstatement. Stop. The contention of the petitioner that he had rendered service, that he had rendered continuous service and that such rendition stands admitted by the respondents involves disputed questions of facts. Stop. The issue the issues agitated were also a part of the title suit preferred by the petitioner, which he willingly withdrew. Stop. The contention of the petitioner, the contention of Mr. Roy, that the appellant should be deemed to have been in regular service is not acceptable to us. Is not acceptable to us. Such argument was rightly discounted by the learned single judge, inasmuch as in view of the inability of the appellant to establish that his engagement was a regular, that his appointment was a regular appointment and fortified by any statutory provision. in the said conspectus, we are the learned single judge upon considering the factual issues have arrived at specific findings, and we do not find any patent error of law in the statements. Accordingly, the writ petition is dismissed. There shall find every এটা তুমি আমাকে পাঠিয়ে দিও। এটা কি এসে খুললো দেখে দিচ্ছি। Sorry, Mr. Roy. Better luck next time.
Lordship, I'm grateful Lordship has given a patient hearing, my lord, that day.
হলো এটা কিছু একটা ব্যবস্থা করো না তো আমি অফারটা দিতেই পারবো এটা তাহলে হ্যাঁ একটু ডেকে তাহলে করিয়ে দাও। হ্যাঁ
Ask them to come to the chamber and you are present.
he will
Yes,
Yes.
Lord. Lord, I have brought the checks for 10 lakhs. Lord, 3 checks I have brought. One of 3 lakhs, another 3 lakhs, another one is 4 lakhs. 3 installment.
Mr. Roy, your client is here. Maybe see.
See, 3 lakhs, 16 1, 16 3, 16 3. What is this? 15 days we said, and today's date, what is
My Lord, he has to arrange the funds, my Lord. It is not that the checks when presented should be honored.
But at least today's check, you must bring it today's date.
One check ought to have been today's date.
You
Lord,
give,
let
you
me
tell him
take.
to give today's
Lord, he is
date.
here. Let me speak with him.
Other check and let him give.
बोला है एक चेक के करंट डेट को दे दो.
We will ask you.
नहीं बस 16 जनवरी को पहले को बोला.
Give a check of today's date. Take back one check.
Very well, my Lord, he will give.
এই 16 ওয়ানটা ওনাকে ফেরত দিয়ে দাও।
And 4243, other 2 checks.
দিদি, this is he will next is after
16 2, 1.5 months.
1.5 months.
That's what 4243.
My Lord, he has to arrange the money. My Lord, as per the agreement, my Lord, I have go down to my client has go down. My Lord.
Say, if you make that, if you are
My Lord, let these 2 checks be of the same date. My Lord, because as per the agreement, my amount would have been much less. The point which I have argued. But I am not saying anything. Let it be.
Yes, yes,
I'm giving it correct.
You,
He will change it.
Mr. Roy, your client is here. Yes. Then you take the check, you hand it, or let him ask him to issue a formal receipt of the checks to him. Ashok.
The only prayer which I'm beseeching, my Lord, is that, my Lord, I'm not asking for the stay of the eviction proceedings, but there must be stay of the rent controller order.
You go and tell the
No, my Lord, the reason is, my Lord, my Lord,
rent controller.
Rent controller order.
পুরোটা শুনে নিতাম।
There is no prayer in this. Rent control order.
Rent controller order, what we want, what you will do, we will say you have made this payment. In view thereof, no interference is called for. Both the writ petitions will be disposed of, and we will request the tribunal to hear it on the date fixed
18/7.
within a period thereafter without granting any unnecessary
My Lord, that is, my Lord, quite obvious, my Lord. My Lord, my client is paying according to my instructions, my Lord, I am submitting. My client has requested me, asked me to submit before your Lordship, is that in terms of the order of the...
Listen to our order, na? We will protect you so far as this payment will not prejudice you in any
No,
fashion.
my Lord, that is already there. The 2 lakhs payment which was
So far
directed
as
by the
this
learned tribunal.
suit is concerned, you have already argued. We have
No,
expressed.
my Lord, I have not argued the matter on merit on the nature of his application. I did not argue at all. If he had argued so much, my Lord, that my stay has been rejected.
Returnable date of the suit, Mr. Roy? It's the eviction suit. Eviction suit which you have filed, they have filed an application under Order 7 rule.
This is,
Check is
that
given.
is, my lord,
First check, did you?
after 106 notice.
First check,
I
he is changing the dates to change the date. No.
I have
Give new check so that
Ask him to issue a new check.
New checkbook le आओ क्या? You have brought the checkbook. He is bringing it, my lord. He will give. Once he has, we have submitted to the court, there will be no this thing.
No,
Whether he has now or not.
He has got, he don't have the checkbook, my lord. The old check is there.
Then
Lordship can record that this is the check. He will replace it by a check of.
he hasn't got the checkbook.
He has not got the checkbook, my lord. He has come with the checks only. Otherwise, he would have replaced it right now.
Then again,
You ask him, otherwise it keep on
He
postponing.
will bring it, my lord. I don't say that he will not give.
When
And
can-
your lordship can have this much of faith on me that once I have said
have
it.
faith on you. It is not a problem with you. But it
No,
is
my
a-
client will honor also. If he has committed, my lord, I
we
see
will
that it is
record
being
that,
committed.
na? We will record
Your lordship
that.
will record it that my client will hand over the check of today's date in course of the day. In course of the day to
When
my
you
learned friend.
tell us we keep it at that time, we will hear it then.
Very well, 4 p.m. my lord, keep it.
4 p.m.
4 p.m. I'll come.
4 p.m. Mr. Roy, ask your client to be here. You take note of the.
To take a photograph or the xerox, keep in the file.
এই দুটো এটাকে আলাদা একটা খাম করে ফাইলের সাথে রাখো 4টের সময়।
He will also make it receipt ready after.
You also, Mr. Rai, you make the receipt ready.
এখন আমি সেটাই বললাম।
You give.
My lord, may I just submit, my lord? Your lordship will record in the lordship's order that we have handed over the checks in the court. That will amount to receipt.
If it is
No
outside, let him
formal
go.
receipt is required.
Counsel, if it is outside, let him go and bring it. If the course
My lord, no formal receipt is required. The lordship can record in the order sheet that we have handed over these checks with these numbers.
What is a number we need? So
The date has to be changed.
Date, that is why, my lord, in the order, when your lordship will dictate the order, your lordship will record that in the order that we have handed over 3 checks of these dates.
So he may have the.
My lord, before
Does not have the checkbook.
he does not have the checkbook right now, so he.
So we are saying you come back at 4 o'clock with the check, we pass the order. Finish.
Yes.
No
certainly.
confusion there.
Yes.
So that he can in the meantime go and bring his checkbook.
Yes, that is why I have said your lordship can
So
keep it at 4 p.m.
we have given back that check. 2 checks are here.
Yes, let it be there.
Yes, come back at 4 o'clock. Yes, next matter.
Item number 13, please.
No, this lady is creating.
But this, the back side is there, that only senior person is like that. So here, delegates are there.
Yeah, that we were. This strip is not there.
Okay.
This long head.
Okay.
Reply exchanged.
Lord, may I file our reply?
You have given.
Yes, Lordship. My lord, I have already filed my opposition and they have served me a copy of the reply.
Served you already?
Yes, day before yesterday they have served.
Lord, this is an appeal and the application for injunction or interim order against refusal of interim order. Lord, your losses will get the order under appeal at page 536. এটা কি দুটো ভলিউমে আছে 10 এর কাছে? Or your losses get it in the memorandum of appeal.
Hey,
MA, this is MAT 465, FMA 426, which is correct number. File is correct, huh? Correct file? Maybe 465. FMA now, FMA numbered.
FMA
Other matter is there, I think this is.
ওই নাম্বারটা কি চেঞ্জ হয়ে ওটা
I
পড়েছে?
think it is not in this connected with this. I think this is not connected with this matter.
This is the MA
465. But some matter is which is not connected to this file is put out.
No, that is number gets changed to be when the final number is placed.
না
it
আমার
becomes
এইটা অর্ডারটাই আলাদা
But that, no,
আলাদা
another, that's not.
নামটা দেখো।
নামটা দেখি
It's
এটা
not
তো
connected with this file.
হ্যাঁ,
If it's number change here also, number change. Other thing 465 is there. This is not connected with this
এটা
file.
তুলে নাও এই ফাইল থেকে।
Each and the same file.
এটা রেখে দেবে আছে এরকম কোনো কারণে আছে?
Well, order dated 15th February 2022
Hmm.
against refusal, your losses.
Page number?
Page
530. Did he take the memo of it? Did he Cambra's memo of it?
Memo of it.
You have to open all the pages.
This one.
No, that is the second part.
Then one. This is after it in the position and
মেমোটা কোথায়? হ্যাঁ, দুটো পার্ট। আহা, মেমো অফ অ্যাপিলটা থাকবে তো?
Justice will find from the impugned order under appeal that there is a refusal of the interim order by recording. তুই বস বস বসে বসে বল কি অর্ডারটা এনেছে নাকি
sorry.
Yes.
Well, last but one paragraph. After hearing the parties and considering the materials on record, I find there is no scope for it passing an interim order. The matters requires to be heard after affording the respondents an opportunity to disclose their stand on affidavits. Well, against this refusal, I have come up. Now, my lord, I tell you losses, my lord, I will take your losses 2-3 pages of the application for interim order.
শোনো, ওটা ঠিক হয়ে গেছে।
127 of the application. The first volume, there are 2 volumes. First volume, your losses.
127.
7. But kindly see the subject, guidelines for engagement of civil defense volunteers with effect from 1st October 2007. The undersigned is directed to request him to follow the following guidelines regarding the engagement of civil defense volunteers with immediate effect. Well, number one, civil defense volunteers may be engaged for a period not exceeding 2 weeks at a stretch in a month following the on the following occasions. Malad, we are really malad, not concerned with the occasions. We are concerned with this clause only. May be engaged for a period of not exceeding 2 weeks at a stretch in a month. So therefore, my lord, we are entitled to at least 2 weeks upon engagement or appointment every month. Cannot exceed more than 2 weeks. At best, my lord, this can be. Now your lordships will find, my lord, page 128, the very next page. My lord, proposal for engagement of driver, my lord, was mooted through the district magistrate of the concerned district. Page 128.
This page 127 is of 2007 guidelines.
Guidelines. The same guidelines, my lord, holds the field still now. Now, my lord, this is the process mooted out. Then your lordships will find page 129. Well, this is the advertisement for recruitment, your lordships, or engagement.
This is in vernacular now, Mr.
I beg your lordships from that.
No, what you tell us, what is this notification for?
Notification for engagement, inviting applications.
For engagement as?
As my lord, Asamorik Protirokha Vibhager, that means Civil Defense Department driver.
Civil Defense volunteer.
Volunteers.
Temporary volunteer.
Exactly, temporary. All are contractual, my lord. It's no dispute about that.
So then you applied.
Applied. My lord, we were interview later. Your lordships will find the very next page, page 30.
Yes.
Now your lordships will find page, we appeared at the interview, page 204. Four. 204. Malad, kindly have a look, Malad, this is of 2018-24. Your request for approval of 4 number of civil defense volunteers to perform these duties under the Civil Defense Organization is approved for the period from 18 August to October 2018, 31st. Volunteers will not be engaged not exceeding 2 weeks at a stretch. That's the Malad guidelines. Okay. Now your losses will find all of us, Malad, were approved, our Malad engagement were approved. But the very next page your losses will be next, but one page your losses will be getting it. Kothay gelo page ta? Ball. 205. Just a minute. I'm not.
Your approval has been given.
Given.
204.
Given. Now we have been performing the duties accordingly. But what, Malad? Our service was being taken for 28 days in a month, continuously.
Exceeding 2 weeks.
Exceeding 2 weeks. Malad, this is not in respect of us alone. I have given, Malad, I have annexed documents. This has happened in respect of others also in other districts. It's not that we are alone. It depends upon the need of the government. They have continuously. Nature of duties is very tough, I tell you, lordships.
How much do you get?
Malad, amount is, Malad, I just amount I get your losses on daily basis. Your losses will get it at page 209. Daily basis I am getting it.
Daily basis.
Daily basis.
Daily basis 10,900.
Well, this is accumulated in a month, your losses, 28 days.
Right.
Now, Malad, that's not the dispute.
Now
Malad,
what happened?
What happened, my lord?
You
all on a sudden, my lord, according to them, there were complaints that we have been engaged for 28 days. Somebody else's have not been engaged for 28 days in other district or others. This might be the best allegation. My lord, on that basis, since August 21, we have not been engaged even for 14 days.
August 21.
One. We just made a representation, then came up before this honorable court.
Where is that representation?
That's representation your lordships will find 329 volume second volume and page 370 both.
There is another, এই এখানে দাও second volume টা।
ফোন করে দেখছে তুলছি না।
309.
370 your lordships will come up.
Now what is 365?
365. Just a minute.
2001 extension.
Extension. Well, this has been extended. These are the admitted facts.
370.
370. We made representations. There are other representations, your lordships.
Now this was of 2021.
Exactly. As I told you, your lordships, from August they are not engaging.
Why did you approach after 1 year?
That's your lordships. Kindly see the salary. If one has to come up, your lordships, daily rated workers.
What interim order do you want?
I tell you, lordships, this is total refusal. Under the guideline, I may not be engaged at best for 28 days, but I may be engaged. Now I tell you, lordships, what I am praying for today before lordships, because I tell you just, before that why I am praying. Our one of the prayer in the read court and before the authorities, before our discontinuation, so-called, that we should be engaged until the age of our 60 years as a contractual workers. Government circulars are there. Contractual workers, daily rated workers will be continuing till age of 60. They will be having certain fixed amount, 3 lakhs of gratuity, all that. This is also our claim. We have come up making all these reliefs before this honorable court.
Hon'ble, what interim?
Exactly. I cannot be given 28, but I can be given 14. How can the learned single judge, with all respect, learned single judge ought not to have refused 14 days relief? I'm a cleft losses. This is our prayer.
14 days is the guideline.
Guideline.
Who were discontinued since 2021.
Well, that's your lordships, man.
Now you are wanting that you engage me for 14 days.
At least till the disposal of the writ petition.
Right.
That cannot be
But
discontinued.
whether in the meantime, what development have happened?
I am coming. That's your lordship called for affidavit. Because the learned single judge says, disclose your stand. That your loss is repeated by the last order. When your loss is directed the affidavit, if I am not wrong, that was the losses of my lord. What is their stand? Kindly have a look at their stand. Why I should not be engaged even for 14 days?
Evidently opposition to the
Probably also may have recorded, may not have recorded, but this is the object, your losses. Please disclose your stand on affidavit. Why I should not be, because my specific prayer for 14 days, interim order.
Petition. That is in the writ petition.
I beg losses.
That is in the writ petition.
That is in the writ. Writ petition, I am paying everything.
Government application for injunction. What is that injunction? Engaging participant. What
give me for 14 days at least.
Injunction they can
Injunction, interim. The till the matter is disposed of, you continue to give me 14 days.
I should not be remotely to peer people. Page your losses 9 of the affidavit in opposition.
Third of now.
I think this one.
No, this is name of affidavit.
Like this.
Oh, this is
Affidavit in opposition. This one, I think this one. That is
opposition. Yes.
page 9.
Page 9, paragraph 4. Paragraph A, B, C, your losses will find the respondent refers to provisions of the act and the rules that we are the civil volunteers. We cannot make the main prayer of the government order benefits. Well, that is to be decided on affidavit in the writ. Your losses so far our 14 days, your losses will be getting a right form. Your losses page my lord 11 my lord F. As your losses kindly come to page 11 subparagraph F. To reconcile the need of the government and the need of the enrolled civil defense volunteers, the Department of Disaster Management and Civil Defense Government of West Bengal, a guideline for engagement was issued. I have taken your losses to that guideline, 2007. Then your losses, it is categorically stated civil defense volunteer is not similarly situated to casual or contractual. This has to be decided on affidavit before the single judge on the writ petition. This is not the issue before your losses. Now your losses straightway come to page 13, subparagraph I. The petitioners are merely civil defense officers or volunteers, sorry, my lord, irrespective of the nature of job performed by them. From time to time, in terms of GO of 2007, they were never deprived from their allotted duties as offered by the authorities. Then why, my lord, they have not given me the duties since my lord, July, August 2021?
Next line you read as and when required.
And my lord, they were not restricted from signing the attendance register. They were advised to sign. If I allot they allot the duties, I will sign. What is the case that I have not signed?
As and when required basis.
Required basis. But where is the case that this is not required? I was required even before the last month, 21 days. And today I am not required. What is the reason for that? That work is being still there. Now your losses kindly see K. Confusion. K is important. It is stated that confusion arose regarding the period of works as to what extent the civil defense volunteers can be engaged. More clearly, whether they should be engaged for a period of 2 weeks at a stretch in a month only, or they may be engaged for a period more than that in that specific month by interpreting the government order in a PC manner. The district magistrate and controller of civil defense Purbo Medinipur by memo dated 12th August 2021 wrote to the principal secretary, Department of Disaster Management, for seeking clarification whether the civic defense volunteers can be engaged only for 14 days at a stretch. Well, that's the guideline. In a month, or may be engaged more than 14 days. Well, suppose a nodal officer seeking clarification from the higher authorities, that doesn't mean that minimum days of work I will be refused.
No, where, what is their statement that as regards requirement?
Nothing, your lordships. I do not find.
What is the order impugned in the writ petition? You challenged 29 July 2021.
Well, that's it, your lords. Give it. 29, I give you losses, right? Just a minute.
Page number 365. Page number 365. This
300?
was second one. 365.
364. Just a minute, madam. Well, kindly have a look at it.
This one. Yes. Sorry, sir.
365.
It's all 365 long sheet.
No, your losses. The second volume, 365 your losses. Probably once your losses picked up that page. Second volume.
Yes.
365.
Please.
Yes. 29/7.
How did you get every page? Why I am not getting it? My second volume. This is my second volume.
Okay, I will take it.
320.
365.
Yes. Thank you.
But as I submitted before losses, we were used to get 21 days in month. By this order, that was given only for 14 days amongst us. This was the impugned order that let's give us 28 days. That's affidavit decided. But 14 days cannot be refused. cannot be denied. And kindly see the stand. They ask for classification. They have never said the job is not required. Throughout entire district, all the district, this job is required.
Your names are in series.
Yes,
1
my lord.
to 7.
The first one, my lord, bottom 14, Bidhan Chandra Pal. He's the appellant before your lordships. And the others are there. Bidhan Chandra Pal.
They were engaged from 15th August to 28th
Exactly, my
August.
lord. This was bifurcated for 14 days only. Before that, my lord, in the earlier month, 28 days continuously. My lord, that's our contention, subject matter. It should not be done. So that should be decided on affidavit.
So when was your total discontinuation? In July 21, they engaged.
After August.
After August
2021.
they did not engage
Maybe.
you any further. How many people are here?
My lord, here your lordships, I think seven.
Yes, sir.
No,
Why?
kindly see their stand, your lordships, once affidavit.
No, one thing is problem. It is totally the need of the government.
That's one aspect.
Today,
I get your lordships pardon. Then affidavit must spell out there is no need of them because of these reasons. This is not the affidavit.
So that will be decided in the main writ petition.
My lord, I tell your lordships. My lord, that's my lord, main writ petition to be decided 8 days. On other benefits. May be engaged, my lord, 14 days at a stage. My lord,
What was the relief sought for in the main writ petition?
main writ petition 21 days continuously as I used to get it. The government orders benefits 60 years up to the age of 60 years continuation. All other benefits like leave.
1 second, listen, because we must understand. They stopped engaging you from September 2001. You filed writ petition. Give me engagement for 21 days. At that time, you did not say that from September 21, even for 14 days, we were not engaged.
I have said that.
You have said that. That means your employment totally denied. From September 21. Therefore, after now the impugned order passed by the against which appeal is filed is only direction to the respondent to file affidavit in opposition after giving opportunity to the respondents
To disclose their stand.
affidavit
Disclose the stand.
and date fixed. Date also fixed for
date
hearing
fixed is
the main writ petition. Now, whatever the stand now you are arguing in the present appeal has to be argued in the main writ petition.
No, my lord, I am not arguing main writ petition. I'm sorry, my lord. I am arguing only for interim relief before your lordships. Because learned single judge has denied interim relief.
So, what is the interim relief sought for and what is the main relief sought for in the, both the writ petition?
My lord, interim.
Both in the writ petition you must.
I just tell your lordships. I take your lordships to.
What is the interim relief?
I take your lordships.
Kindly come to page
64.
This order is curtailing their service from 30 days to 50.
Restricting 14 days. Restricting.
That was
365.
That's your lordship first prayer, impugned order dated 29 July 2021. My lord, this is my lord, minimizing or curtailing from 28 to 14. That we have questioned. Then your lordships will find the other reliefs under the respective government orders we have prayed for. And we have prayed for the interim order to allow the petitioners to perform their duties in earlier occasion, allow the petitioners to sign that and then register. So this was the relief in continuation. C.
Last.
C and your lordship, interim order your lordships will find at page F, page 66 F.
You also prayed for an injunction not to fill up the vacancies.
That's
of
your
the-
losses. But kindly see consequences of
Mr.
that.
Sannal, you can, whether it has to be ascertained, this is not a sanctioned post, it is temporary.
But I'm not, I get
So
everything.
you can argue that before the petition is disposed of, you please do not appoint anybody else in my place. That may be subject to what you say, that may be an argument. But Mr. Sannal, at this interim stage, how can we say, placing upon the advertisement that you immediately engage?
May I
We can understand that you are saying that, see, interim order, we prayed that, all right, you have curtailed from 14 days, because at that time you were not also having the idea whether those 14 days will also be taken away from you.
Because they have taken away.
Now the intention that, so in the writ petition which you filed, you primary challenge is against the order curtailing your period of service. Now,
May I take your losses to the
that page 365 is 15 days
No,
curtailed.
I tell you, losses. Kindly come to page 56. Running page 56.
We can at best you can argue that before till finalization you should not engage anybody there.
Other relief I can satisfy your losses. Give me 5 minutes, I can. I can.
But
Kindly have
what
a
do you say?
May I
No,
assist?
no, don't say anything. You will argue, we are wanting to know. This is you. Have you in their place? Is anybody else working?
They have not disclosed on
You
affidavit.
have not disclosed in the. You are our officer. We are wanting.
I shall take 5 minutes, Lordship.
Achha, take no, answer our query first.
Yes.
Is there to 2021?
Yes.
They were curtailed from 28 days to 15 days.
Yes.
Subsequently, they were discontinued totally.
Yes.
He's saying that when, as per guidelines, you can give me 15 days, why did you snatch away that source from me also?
Lordship.
That is the pain he is facing. He's saying that, all right, we protested. You took away, your curtailment was done. Now they are in desperate situation.
Yes.
Because 15 days engagement, paltry money that will be given by the government on the basis of their service. So when we were hearing this, we asked you that is it a fact that somebody else have been inducted?
No.
Then in that case, what is the problem in giving them for?
My lord, sir. My lord, kindly takes up my affidavit in opposition. Page 57. Page 57 of my opposition. And this is the order of the division bench. Kindly see. Having regard to the order impugned dated 15 February 22, which has kept pending without determining the rights of the parties, the maintainability of this appeal also requires to be considered. Learned State Council, such and such, learned senior government advocate submits the affidavit in opposition to the writ petition as directed by the Honorable Single Bench has been prepared and served on the writ petitioner. However, writ petitioner appellant seeks to an opportunity to address this court opportunity. Accordingly, certain. My lord, we have served copy. My lord, they chose not to file any reply to our opposition. It's not that the direction was not passed, opportunity was not given. My lord, affidavit has been filed. Immediately what they did, they preferred an appeal for refusal of interim order. That is on record. It has been filed and it has been served upon them. My lord, now I am coming to, kindly see, page 129 of their application.
Sir, it is very difficult for us to continue. We are asking a
Yes,
question.
yes,
You are not bothering to answer.
Lord,
You are
Lord,
showing. We know he has a bad case. We are trying to know from you.
And they are not even a contractual employee. That's my submission.
Then why did you engage them?
Well,
that contractual employee, whether they will get 60 years benefit or not,
No,
those they will not get.
No.
We are not on
No,
that
but
point.
they are asking for regularization of all those
Oh,
documents.
no, they are saying do not do anything. Only give me my bread for 15 days.
Well,
This is
as and when it will be required.
that is exactly where that there
If
is
it is
no.
not required, Lordship,
Where have you said that it is not required? Show us one line. Finished. That it is not required, sir. We cannot give it. Government has no requirement to proceed with you for 15 days. So that is what we wanted to know.
my lord, since 2021.
I think
My lord.
that I have expressed myself. But
My lord.
still, if you go on to that point,
My
we are not saying they are contractual or they are regular or they are entitled to absorption.
Lordship.
We are on the last day also we asked,
Lordship.
requested you that Mr. Chaudhary kindly tell us
Yes.
that this discontinuance which was done in 2021.
Yes.
Today, how can we say that immediately you engage?
Yes.
If the government requirement is not there.
Yes.
So show us from your affidavit where you have said that it is not, their service is not required at this juncture.
Lordship.
One line in your affidavit.
Lordship.
Finished. People will not write that line and
My lord takes up page 11.
11.
Yes.
Yes.
From the conjoint reading of the regulation 8 and 9, it is evident that the civil defense volunteers will serve in the voluntary and honorary capacity. They may be assigned on any duty on emergency basis as per requirement of the government. They have no right to claim any continuous service.
They are not claiming,
My lord,
sir.
they are not entitled to get casual, contractual or daily.
See now what brother says, where you have stated that they are not required now, where you have stated. See, as and when necessity arises, we will engage. Now there is no necessity.
Yes.
There is no requirement. Where you have stated in your affidavit.
That is for
My lord, may I say, page 15.
that is for total engagement. 28
No,
days.
no, that is, I am showing on the district authority has faced a huge number of deputations.
Read the paragraph.
And agitations by the other enlisted civil defense volunteers apart from the petitioners. Civil defense volunteers as to why these 7 civil defense volunteers are getting more preference than others, irrespective of their equal quality experience.
Exactly.
Yes.
That is why you have curtailed. That is why you curtailed
Yes.
from 30 days, 15 days.
Yes.
So when these people are surviving on that engagement, they are surviving. You could have written one line here that today there is no requirement for these drivers.
Yes, my lord.
Where is that?
May I submit one more thing? It is also true that we never, my lord, we have taken this point in our affidavit.
Supporting. Benefit of the government service. But why do you that list? Then the petition becomes That means instead of petition, we accept and do it for that review order restricted not putting this. That they did not accept and filed a petition. Now he wants putting this. That means he is not going to change the after 10 days, you did not accept.
My learned senior friend has pointed out one thing, but he has skipped one thing. Kindly turn to page 204 of the application. Kindly see the last paragraph. The said allotment duty which is made on daily allowances basis does not confer them any right of appointment or
One
absorption.
second, Mr. Counsel.
Yes.
Now he has filed a writ petition challenging the order restricting their working days.
Yes.
14 days.
Yes.
So now, according to you, 28 days due to the agitation by others, you are not allowing them to work for 28 days and restricted to 14 days.
Yes.
That you are 14 days you are willing to
Yes.
give.
Yes.
You are willing to give. Can we record that?
If required and after 2021.
No, if required, correct. If required,
If required.
wait. If you required, you will
Yes.
engage.
Yes.
Then where you have stated in your affidavit that there is no requirement, therefore we are not engaging. You point out. That's what we are wanting.
We will dismiss their writ petition and we will say that you will engage for 15 days. Finished. Every story goes. All your problem goes.
Yes.
There will be no discrimination with other district.
No.
They cannot claim regularization.
No.
They cannot claim full-time appointment. All will be in your favor, but engage them for 14 days. Finished. The entire episode, we will take the, Mr. Sannal will state that we are doing away with that. You give me engagement for 15 days.
My lord, may I submit? My instruction is, lordship, and they were asked to join, but they did not turn up. Not only that, up to 2000, and I have stated in affidavit.
Where have you stated?
Lordship.
In the affidavit, have you stated that
Lordship.
they were asked to join, but
Lordship,
they did not join?
Lordship.
We have to see. We have to check all the lines. You redrafted your opposition to the writ petition in this.
But we will not know where.
Where have you stated that line that after the impugned order,
yes,
they were asked to join for 15 days, but they refused? Show us one line.
You made us to read entire.
And we will not do so because they filled up those posts for 15 days by issuing an advertisement. Now, if they want to fill up that post, they will do re-advertising. We're right. That take that satisfied with it, then we can. 14 days. 14 days. Be satisfied with it.
That he may subject. That's not.
He will not because he will lose the other. He was equal status with temporary employees. That you cannot claim that is
Well, that particular government is not.
So that is not there, then where,
Not
how
there,
to say that?
This was the question we put to you at the initial stage also.
Matlab, they cannot, because civic volunteers need is matlab, permanent need throughout the country.
See,
That
now,
is permanent need.
no, now you get instructions, or tomorrow we post it, you get written instructions that you will engage them for 14 days. You get written instruction. According to you, 14 days, you have no objection.
Well, their initial complaint was something different. They were asking for more than 14 days.
They will not ask, we will say. They will not ask for a day more than 14 days.
Yes.
You have filled up those by publishing an advertisement.
Lordship.
Huh?
Lordship.
After the advertisement, did they ask you that though I am entitled to 14 days, give me 130 days duty? They did not ask you. You suo moto gave them. Now suddenly you curtailed it. Why? Because in other district it was 14 days as per guideline. Very good.
Yes.
You did a right thing.
Yes, yes.
You did a right thing. Now they will accept that. Their challenge was that you cannot curtail my service from 30 days to 14 days. That was main writ petition. And I am entitled to benefits claimed under the Sarva Shiksha Abhijan and others for 60 years.
No, this is general government order of the state government, respect of contractual and daily rated workers. This is well known to your lordships also.
That is for 60 years. We will not go into that issue.
May I take 2 minutes of your lordships?
No, before that, we will take 1 minute of yours. You have no case. Asho, দেখাচ্ছি এবার। Page 57.
Page 57. Yes, no, no.
First, second, third, fourth.
Running page 57. Fourth.
The appellants writ petitioner are unable to persuade this court at this stage on the requirement of an interim order. This is the appeal court order.
Which one I couldn't find?
Page 57 of the affidavit in opposition.
Yes.
Oh, affidavit in opposition. Yes, my lord. The second page.
First page. 22nd August 2022, when the stay application was moved.
That was for 28 days. Requirement. That was for 28 days.
Interim. See, interim order, either way you cannot say. We asked a question, what is the interim order you are seeking? You said you engage, ask them to engage us for 14 days at least. But interim order, that was refused.
Refused, my lord, I tell you lordships. Interim order.
1 second, counsel. 22/8/22 itself, it was refused. Then now you cannot ask for another 15 to 22 order. You cannot challenge now.
No, I'm not challenging your lordships. I'm not questioning of your lordship's order.
No.
All that
our order. See, earlier this bench, not this bench, coordinate bench, refused interim order.
I got your lordship's point. But may I make submissions? Once refused, that doesn't mean that your lordship doesn't have power in the subsequent facts pass a fresh interim order.
What subsequent
facts? I tell your lordships that I
change in circumstances.
Circumstance change, but the prayer is changed because I am entitled to survive for 15 days. I'm not asking for the main prayer, your lordships. I can pray for 15 days, and that's why your lordships kindly have a look at the affidavit. They, due to their confusion, they did not allow us.
Make submission before the writ court and say that withdraw the writ petition. We are ready to work for 14 days as per the individual order.
Your losses, that will be, kindly do not take me away. It's a judicial force. Kindly, your losses, do not do that. If I am entitled to, that's I'm wanting to.
No, there is no force, Mr.
I tell you, losses.
My sister is saying that let us divide it into 2 parts. 30 days engagement you were enjoying, it was withdrawn. 15 days left. Now you are saying that it is a question of livelihood. Allow me to continue for
interim order.
Allow me to continue for 14 days. But in the main writ petition, what you have said that not 14 days, I want 30 days.
Of course, 30 days or 28 days, along with other release, that will be decided on the affidavit. Because I tell you, losses, why? Kindly come to page 30 of 341 of your lordship's brief, second volume. Kindly have a look. Because we were recruited not from the Malad backdoor procedure, through an advertisement, regular process.
What we can do, Mr.
No, I tell you, Lordship.
The coordinate bench has refused your interim.
But that's your lordship.
Trying to help you out. We wanted this.
Full interim order, your lordship. Well, kindly have a look at page 341. Well, that's I have come up for that. Your lordship, my lord, kindly page 341. 341. I will be making two submissions, then I will not.
My lord, may I point out one more thing, lordship? I have taken one point in the affidavit, which my learned friend, senior friend, has failed to satisfy in the reply. That source
Lord,
source of availability of the internal documents.
That's the last coming to.
Mr. Chaudhary, it is very difficult to make you understand what we are wanting. We are wanting an answer to a question. You are taking us through the whole universe. You also know that court is asking something which I have not stated in the affidavit. Now let me try how I can dilute the issue in another. We are in this institution for almost 25 years. So don't apply certain thing which is not expected of you. Court being humble is asking. And you take 2 months of time and you don't write a line in your opposition that, sir, there is no requirement for engagement for 15 days also at this stage. Let the petition be finally decided.
They cannot write it because the requirement is there, my lord. How can they write it? They have written everything. They have taken your losses through whole of the act itself.
He has no answer. No? Can you bring an answer from your authorities that 14 days we can engage? And we will dispose of the entire issue. Are you agreeable to that? 14 days you will continue as per the...
This answer I will give you losses
That
right
instruction
now. Kindly your losses.
No, Mr. Shanmal, you cannot have both sides of the cake. You decide that if you are 14 days, we will dispose of the writ petition as well as...
just your losses give me simple bread. Your losses cannot take away the sandwich also.
No, we are not asking you to do that.
For the time being 14 days I am. But your lordship, kindly come to 341, your lordship. I will show two things to your lordships. Page 341.
Yes, 341.
341. Kindly see this list. These people in the other districts are being engaged even for 30 days. So it's not that, my lord, as because we were engaged, any complaint was raised. This was on affidavit without any evidence.
When it was done in 2021 July, curtailment was 14 days. Did you write to them, you have give me for 14 days at least? Did you make a representation?
Suppose your lordships, a person is working for 5 years to 28 days. He is managing his family, everything.
We understand
now, 1
that.
day, your lordships make it 14 days. Any person will go and ask, let me 10 days alone. Kindly do not bat your lordship.
Don't make that argument. Your discontinuance was in July 2021. You made a representation that you cannot curtail it to 14 days. And that you have continued consistently with that.
Initial, when the curtailment was there, the 14 days, I performed that duty with a representation. Please extend it for 28 days. Then they stopped it. How could I make a representation, my lord? As soon as they curtail it, I made a representation. I performed my job. From the next month, they stopped it. Now, two things, your lordships. Other districts having 28 days. So that I am not alone. First. Second of all, affidavit, your lordships kindly have a look.
How to make submission in the main writ petition?
That's one thing. I'm just clear, making the I'm making the conscience of your lordships clear. And affidavit, they cannot improve more than this affidavit. You kindly see, higher authorities was in confusion whether can be engaged 28 days or not. This is the whole of the affidavit. It doesn't say about that my job is not required. Only confusion. So they wrote a letter and sat tight over my claim.
My lord, in this fashion, they are also putting pressure upon us to give 30 days work.
No,
My lord, that is their object, lordship. They are not satisfied with the 14 days work.
exactly.
And
that is why
one
we
more
are
thing,
asking you.
up to 21, entire amount has been paid to them. They have made a false allegation that they have not been paid. Amount is pending. That is not that.
Where you have discontinued, was there any order? Did you issue any letter after 29th of July that why you are not joining service for 15 days? Have you ever told it to them? How can we understand that issue? Tell us that you offered, he did not accept. Your argument is that
Yes.
that he thereafter they did not turn up also.
No.
Where from we will find?
Well, I can take that instruction whether they can be provided with 14 days work. That instruction I can come back with. 14 days work.
Yes, Mr. Shandal.
Well, I get your losses point. Now, suppose your losses, they come up and say no. On affidavit, this is the first, they cannot, my lord, take a chance before they are court.
Make up your mind first, Mr. Shandal, whether you will be satisfied with 14 days.
Yes. For the time being, 14 days I'm satisfied.
No, not
Subject
for
to the writ petition, my lord. Writ petition cannot, my lord, your losses disposed of. I'm against the interim order, my lord. As an interim measure, your losses can do that. My writ petition should, my lord, the other reliefs I have paid for, because I'm contractual employees.
Sorry, Mr. Shandal.
Then, my lord,
The present writ petition affect their main writ petition.
Ask them to disclose it without giving any agenda.
You can maximum keep it on 10 hours from him whether you can give
But he may not be satisfied with that. So
you're saying accept 15 days and forget what's that also we cannot.
that's what's in the using the bodies. So I used to
They will come. Where is the place? All right, Mr. Chaudhary, we keep it on 10. You come with this instruction, we dispose of the matter. Can you come or sure you can improve on this or not? Or we pass our order?
main writ petition you filed affidavit in opposition.
Yes, lordship.
Reply also filed.
No. That is on record. That is why I pointed out.
Mr. Shandal, you are not agreeable to that, no?
I tell you, lordship, writ petition affidavit have not been served on us.
Well, that is on record. That's why I have annexed that order.
Malad, I have not been served. I'm saying kindly let
My
me
learned lawyer
understand
was
it.
there on that day. I was not there, but she filed it, and that
I have
has
not
been
been
kept on
served.
record. That has been
So
served.
let us see the service.
That has been
I have
served.
not been served.
That is why I have annexed that particular order.
The present appeal has been preferred, challenging an order dated 15th of February 2022 passed in a writ petition being WPA 407 of 2022. By the said order, the appellant's prayer for interim order was refused. Mr. Sannal and the advocate appearing for the appellant submits that by the order impugned in the writ petition, the petition, the appellant's engagement for the entire month was reduced to only 14 days. Stop. Thereafter, reduced to 14 days. Subsequent thereto, in spite of repeated representations, the respondents did not even engage, did not even allow the appellants to continue for 14 days in a month. For 14 days in a month. Stop. According to Mr. Sannal, the writ petition was filed praying for several reliefs, including a prayer for allowing the appellants to continue till the date of retirement, till the date of the retirement age of 60 years as per government circular. Stop. During pendency of the said writ petition, the learned single judge are in law in not directing the authorities to continue the appellants to work for 14 days as provided in their guidelines. Such discontinuance has severely affected the livelihood of the petitioners, livelihood of the appellants. Stop. Such issues as urged were glossed over by the learned single judge and no finding was returned on the same. Stop. Such infirmity warrants interference of this court. Stop. Mr. Sannal further submits that in the affidavit in opposition used in the present appeal, the respondents did not make any specific averment that the appellant service for even for 14 days is not required at this juncture. In view thereof, the said respondents cannot deny engagement of the appellant, at least for 14 days. For Mr. Chaudhary, learned advocate appearing for the respondent submits that after the issuance of the order impugned in the writ petition being dated 21st of July 2021, the appellants did not approach the authorities to allow them to continue for 14 days. Instead, it was their claim that their initial appointment for 30 days per month should be continued. Whether such stop. The issues as to whether the petitioners appellants can avail the benefits as provided to other contractual employees in other departments of the government is a matter to be decided in the main writ petition. And to that effect, and as directed by the learned single judge, an affidavit in opposition has also already been prepared on behalf of the respondents. Mr. Sannal, however, submits that no copy of such affidavit in opposition has yet been handed over to the appellants. Stop. Heard the learned advocates appearing and considered the materials on record. Stop. The issue as to whether there is any requirement for the respondents to engage the appellants at this stage for 14 days. Including the issues as to whether, including the issue as regards sustainability of the order dated 21st July 2021. Are all pending for final consideration before the learned single judge. Stop. Records also reveal that when the present appeal came up for hearing before a coordinate bench of this court on 22nd of August 2022, the appellant's prayer for interim relief, interim order was considered, and it was observed inter alia that, quote unquote, the appellant stroke writ petitioners, page 57, are unable to persuade this court at this stage on the requirement of an interim order.
May I make one submission?
Mr. Shannal submits that in view of such observation, submits that there had been a change in circumstances subsequent to issuance of the said order by a coordinate bench of this court, and in view thereof, the appellant's prayer for engagement for 14 days, and in view thereof, the appellant's prayer for engagement at this stage for 14 days per month cannot be received. Such argument of Mr. Shannal is, however, not acceptable to this court in the facts and circumstances of the case. Accordingly, we are not inclined to grant any interim order at this stage. However, we request the learned single judge. Stop. Copy you have, opposition copy? A copy of the affidavit in opposition used by the respondents is handed over to the learned advocate on record of the appellant in court today. Stop. The appellants would be at liberty to use the affidavit in reply to the same within 2 weeks from date. Stop. The learned single, you don't have? The learned single judge is requested to dispose of the main writ petition as expeditiously as possible without granting any unnecessary adjournment to either of the parties.
Only one thing about your loss is the earlier order of the coordinate bench that was at the motion stage. Your loss is now hearing the appeal. Motion stage could not persuade.
Mr. Bolle, there has been a change in the circumstances, and furthermore, the said order dated 22nd August was passed at the motion stage in the present. Accordingly, the appeal and the connected applications are dismissed. There shall, however, stop. It is the observations made. The observations, the learned, and the matter will be decided by the learned single judge without being influenced by any of the observations made in this order while considering the petitioner's prayer for interim relief. Or influenced by the observations made in this order. Yes. Hmm. We wanted to. This upon your, this upon my heart. This is. How can we say that we are proceeding? See his submissions. This will disturb you and will affect you. Correct. These are loose comments. These are not necessary. Yes. Bolo.
My lord, I'm for the appellant. Uh, I'm led by Mr. Joydeep Kaur. My lord, in this matter, the paper books have been exchanged and Mr. Kaur has already completed the entire argument on behalf of the appellant. At the time, your lordship had been sitting with his lordship Parthasarathi Chatterjee. Parthasarathi Chatterjee. The arguments were completed and subsequently date had been given for counter argument.
Not this week. Next.
Not this week. Mr. Kaur is here.
Yes, next.
Agenda number 16.
Lordship, item number 16, I appear for the appellant.
I appear for the respondent numbers 1 and 2, Your Lordship, led by Mr. Shuddha Banerjee and Mr. Devmallo Ghoshal.
Lordship, this is the matter.
Where are they? You will argue the matter?
Your Lordship, they are on their way, Your Lordship. He can begin. Here, they are the appellants, Your Lordship. I'm the respondent, Your Lordship.
So don't pray for any adjournment if they get stuck on their way.
Lordship. Lordship just takes up Lordship's last order on 11th of...
This is a first time it has come.
No, Lordship, the second time. On the first occasion, I was led by Mr. Piyush Chaturvedi. He argued before Lordship. Lordship gave us a chance to leave to file a supplementary affidavit. Lordship takes up Lordship's order dated 11th of December. Lordship, it's here, the original copy. It has been served. The original.
It has been served.
To them, Lordship, on the 16th of December. This is the supplementary affidavit.
Lordship, we have been served with the supplementary affidavit.
Also the state, Lordship. Lordship, this is the supplementary affidavit.
You want to controvert any portion?
Lordship, only just one thing, Your Lordship. On the last occasion, when I was led by Mr. Ghoshal, Your Lordship, Mr. Ghoshal had clarified before Your Lordship that the petitioner, who is before Your Lordship, he was being paid gratuity in terms of the West Bengal Financial Corporation gratuity regulations. Now, Your Lordship, his case was that subsequent to an amendment on the Payment of Gratuity Act in 2018, he is entitled to 20 lakhs as gratuity. Now, Your Lordship, the West Bengal Financial Corporation is a corporation which is under the control of the state.
Why it has come before us? It is a Gratuity Act issue.
Lordship, this is a Group 6 matter, Lordship. It's not pertaining to Gratuity Act. May I just say this, Lordship? Lordship was pleased and Lordship was pleased to entertain this also. Lordship, I have retired from my services. I was rendering my services before the corporation, West Bengal Financial Corporation. I retired from my services. Now, Lordship, the corporation has an arrangement with the LIC where the corporation keeps paying monthly payments, and the LIC, as and when the employees are retire or superannuate, the LIC.
Your writ petition was disposed of at the motion stage.
Lordship. After affidavits, Lordship.
After
affidavits were exchanged.
You have filed any stay application?
Appropriate orders, Lordship, not a stay application. Lordship, the supplementary, Lordship, may I just say this?
No, we are wanting to know whether pleadings are complete or not.
Pleadings are completed, Lordship. It's all here.
Opposition has been used to the stay application.
No.
Lordship, we have not, Your Lordship, in the month of September, when this application had come up before Your Lordships, to expedite the matter, Your Lordships had been pleased to dispense with the formalities of paper books.
I'll just say why, Lordship, why it fell from Your Lordships that way. Lordship, the only bone of contention of the financial corporation was that the state government had not accorded them the approval to give the higher amount. Lordship, we have come up with the supplementary affidavit by which there is a notification of the state government, where the state government now in the notification says that amounts will be disbursed up to the ceiling of 20 lakh rupees as in proprio to the Gratuity Act.
Will pay it? The state?
Lordship, it will be paid by the corporation only. Lordship, the bone of contention. Lordship, may I just summarize?
The gratuity amount you are claiming according to the
Gratuity
according to
Act.
your employer,
Lordship.
it is to be paid by the government.
Lordship, it is to be paid by the employer because Lordship will appreciate that it is a financial corporation.
As long as you get the amount, you are happy.
Lordship,
The-
I'm
what
happy,
else?
Lordship. So the
Yes, Mr. Ganguly.
Lordship, I'm led by Mr. Chaturvedi.
State can pay.
My lord,
That no supplementary affidavit have you given to Mr. Ganguly?
my lord, we have received it. My lord, today, my lord, basically I need some amount of.
So, Mr. Ganguly, dispute was that as regards gratuity payment,
My lord.
Financial Corporation says that whatever dues you are claiming for gratuity, that has to be paid by the state, not by us, subject to what they say.
Yes,
subject to what-
No, my lord. No, but this our contention, your lordship, is slightly different from your lordship. The payment of gratuity by WBFC is made by LIC, with whom the premiums are deposited by WBFC and LIC disburses those amounts. Now, your lordship, when the petitioner retired, he was given 12 lakhs as gratuity because that was the rate which was prevailing as per ROPA 2016, which also governs our corporation. Now, subsequently, your lordship, we have sent letters to the state government stating if we are allowed to disburse 20 lakhs uh, from the payment which we have received from the LIC, but the government had
You have the money with you.
yes. Yes, your lordship, it was paid. We have given him 20 lakhs, and as per instruction, your lordships, 8 lakhs have been kept in a fixed deposit.
Why? Why?
Your lordship, because the state government had expressly prohibited us from paying 20 lakhs.
Now the new notification you have
Your
considered.
lordship, your lordship, the new notification has come out on instruction, your lordship, on 30th of November. We have asked for clarification from the state government if in terms of the new notification, we can now disburse this amount. That clarification has not yet come here. On 30th of November, your lordship, we
Show
have
us that letter that you
your lordship,
got for
it's-
clarification.
your lordship, as per instruction, it's an e-office note, your lordship. It's an internal communication. I have the reference with me, your lordship. That reference I can provide to you.
It is to the which
To
department?
the finance department, your lordship.
They need the concurrence of the finance, so that
department.
they will pay with the concurrence of the finance, my lord.
Mr. Ganguly, you can solve the issue.
My lord, in that occasion, my lord, I have to.
Yes, yes.
have
We
to
will
some-
we will give you that time. You have you consult your finance department. It's a question of concurrence, not a question of debiting of
Yeah,
any
nothing.
government.
We have to only. So they will do the needful. My lord, if your lordship may
Let
kindly
me
take out one line order, my lord, so that we may take a specific instruction to this effect.
Mr. Chaturvedi, learned advocate appearing for the appellants, files the supplementary affidavit with copies to the learned advocates appearing for the respective parties. Stop. Let the said supplementary affidavit, comma, as filed, comma, be kept on record. Stop. Mr. Ganguly, learned advocate appearing for the state respondent.
My lord.
You are for all these AGP.
State is respondent 3.
Learned is directed to avail necessary instruction. Is directed to avail necessary instruction. Stop. Leaves the matter. Yes. When can you come with that? Tell us, Mr.
My lord, my lord, 2 weeks is required, my lord. So far, my oral instructions are concerned. My lord, by that time, the what?
One thing, Mr. Ganguly, if this concurrence is to be given, decision has been taken, you please come to us with that concurrence.
Yes,
Then
yes.
we can dispose of the matter
yes,
on
yes.
the basis of that.
That's why, my lord, we will come up with a specific recording of this.
The matter for further consideration in the daily supplementary list of this court on on 24th,
22nd to 25th, my lord, I am with
so then it will be on 29th.
29th. I'm grateful.
29th.
Grateful, my lord.
I'm grateful, my lord, deeply of that.
Yes.
In this matter, I'm for the
Let's return say that close one.
on the last occasion, my lord.
Yes. Yes. Yes, Mr. Bhattacharya.
My lord,
Problem solved or
no,
problem
the
remains?
problem could not be solved. My lord, I tried my best. I conveyed your lordship's desire, but there is, my lord, I have received this instruction. My your lordship kindly produce this. But may I hand over another, my lord? It is my signature is there, my lord. May I hand over.
Your signature, later
Receiving signature is there.
we will apply it.
I tell your lordship before your lordship going, because this is a really employee diet before my lord, thrice he got married. My lord, the first wife died. Now the second wife has come before your lordship for payment of the general benefit. And so far the payment is concerned, it was we went to the tribunal. Tribunal rejected the claim, my lord, holding that not validly marriage wife, and unless succession certificate is obtained, my lord, it cannot be given. And your lordship's desire was that since Rule 75 provides that two wives is entitled to get the unequal share, my lord, then that can be disbursed. Your lordship's desire. Since the money is there, you can disburse. But to that, their my lord, views is that, my lord, the two wives, they without talaq, my lord, they have the wife, under the Muslim Islam law, my lord, the lady cannot marry more than once. My lord, this is monogamy. My lord, that is the problem standing in the way. That is why, my lord, the authority has decided this cannot be paid.
We didn't follow.
My lord, under the Islam, my lord, a male can marry more than one, but a female, my lord, cannot get married more than once. Cannot have more than one husband. But this is a case where, my lord, before getting talak from the previous husband, the present petitioner has is claiming my lord, he is not entitled to.
My lord,
In that view of
the
the
fact, my lord,
that has been
present petitioner was widow at the time of
but before my lord,
no, present petitioner was widow at the
and
time of marriage.
third wife also with before
Hard wife, my lord, that is
my lord's desire to.
Why don't you keep your boxing gloves? You can immediately give him a punch once he says.
My lord, your lordship kindly peruse the once again the instruction.
What instruction? I don't know. A lady, whatever married, these people, they do not know. Suppose the lady had married, you are submitting that the lady who married the petitioner who died in harness was previously married to
And
somebody else.
without having talak.
You know that talak
Man,
was
that
talak, how it is given, there has to, like Nikanama, there has to be a talak.
Nikanama, that is mentioned in the instruction.
People as if they are.
What is the earlier was this? The exception is
There was a dispute, there were three wives. You were there.
Deceased petitioner.
Oh, sorry, it was Gouda.
Ladies petitioner.
Lady is the petitioner, he happens to be one of the wives of the deceased.
Okay.
Now the deceased married thrice. Now the tribunal, now there was a dispute as regards who will obtain the pension.
But according to this second one.
Tribunal said nothing to do. 275 provides that why succession certificate if it is amount given somebody else might have. So rules provide if it's at least for family pension, if there
Talak divorced from their first husband before marrying the late Muhammad.
Now he's saying
It is a leakage.
there are two wives, but the one of the wives married the deceased without obtaining talak from her previous.
Both the second and third wives legal, wives illegal talak from their first husband before marrying late Muhammad. That
So, Mr. Bhattacharya, you pay the half amount to him? What is your problem?
the first wife.
You don't want to give it to second wife? on an allegation that the second wife before marrying the deceased was married to somebody else from whom he did not obtain talak. This is your content.
And your lordship kindly peruse, my lord, paragraph, my lord, as per Article 21,
Where you are reading?
second paragraph of the, as per Article 21. Has your lordship got it, my lord? Servants Conduct Rules 1966, duly circulated by CPO, serial number such and such, copy enclosed. Both the alleged marriage of late Noor Ali Khan with Chakina Bibi alias Sakina Bibi and Farida Bibi stand null and void due to the fact that the late Noor Ali Khan had violated the provisions of contract rules while marrying with the so-called second and third wife. As second and third wife. Has your lordship got it, my lord? As stated above, nor did both the second and third wives took legal talak divorce from their first husband. Both the second and third wife having, my lord, first husband, without taking talak from the first husband, they got, my lord, they married before marrying the late Nur Muhammad at material point of time. So the marriage are fully illegal and disputed in the eye of law. Now, had they been, my lord, legally, validly married wife, according to the railway rules, my lord, they are entitled.
Have you used affidavit in reply you have filed? To the main opposition? You have filed?
Yes, my lord, only one point, my lord.
Yeah, we will listen to you. That reply is here.
Yes, my reply, I shall affirm, my lord.
You have not yet affirmed.
No, my lord, I have not affirmed.
Achha, what you are submitting? What are you submitting?
My lord, my page 20, my lord. Kindly see page 20.
Page 20 of what?
My petition, my lord. Here, my petition, my annexure, my lord. Page 20, annexure P2, my lord.
Bengali.
19 state, Bengali, my lord. My lord.
This is totally in Bengali.
Bengali, my lord.
How my sister can understand?
Lord. My lord, I am saying, my lord, then, my lord, I shall
take this point in your affidavit in opposition.
This has been specifically, my lord, observed in view of your lordship's directions, my lord. In view of your lordship's direction, this has been specifically, my lord, I have taken instruction and
you do one thing, you file your reply to the opposition which has been filed, we finally hear out the matter. When can you file the opposition, tell us?
My lord, he is old lady, my lord. That is why I have to, my lord, took him, my lord, into court, my lord. Next week, my lord. My reply is ready.
1 week time.
1 week time, my lord.
Then not this week, you come on 10th.
My lord, if my lord, translation is required, my lord, this is very much essential. This judgment.
Whichever vernacular document you want to rely, you make a type copy of the same.
My lord, at present there is no, my lord,
You come, we will see. If it is possible, I will tell to my sister. She will consider. Finished.
Only one line, my lord, may I read, my lord?
For what reason, sir?
My lord, the admission of the employee that after the death of first wife, he married the petitioner.
Have you read this, what he is saying?
No, no.
Have you given a copy?
No, your lordship has not. This is for only for your court, my lord.
You give a copy, Mr. Bhattacharya, so that he can deal with it in his opposition.
Yes, ma'am.
All right, 10th. 10th, 11th?
10th, my lord.
10th রেখে দাও, এটা ওনাকে দিয়ে দাও।
আমি এখনই দিচ্ছি। আমি যেটা এই কপি আছে আপনাকে দিয়ে দিচ্ছি এখনই।
Where is this railway conduct rules?
এটা দেবে কাগজটা
Take this copy also.
Yes,
একটা copy ওনাকে দিয়ে দিও। And Mr. Bhattacharya on 10th, you please come with the railway conduct.
আরেকটা কপি দেবেন আমি দিয়ে দিই এখন এটা মানে আই এম টেকিং ব্যাক
You
বোথ
take back both the copies. You give one copy to him.
মানে আই এম ইমিডিয়েটলি গিভিং বিকজ আই এম মাই অফিস কপি আই এম
একটা অর্ডার লিখে নাও। Mr. Bhattacharya, learned advocate appearing for the respondents has placed before us a copy of the written instructions. Let the same be kept on record. A copy of the same has been handed over to the learned advocate appearing for the
It's a copy and kept on record.
Mr.
I'll give
Bhattacharya,
a
give
Xerox.
one copy on record.
I've received one.
Copy of the same has been handed over to Mr. Mondol, learned advocate appearing for the appellant
I
in
Xerox
court
it and give
today.
it to you.
In court today. Stop. Mr. Mondol, press for leave to file the affidavit in reply. Press for an accommodation to file the affidavit in reply. Stop. Let such reply be filed within how much time you require?
By Tuesday, my lord, I shall file.
9th, before 9th, you will.
9th, my lord.
Also not 20.
বললেন file reply let such affidavit in reply be filed within 9th. Stop. With a copy to within 9th of January with a copy to Mr. Bhattacharya. Stop. This is the matter for further consideration on 10th. Yes.
And it will be immediately hand over to your lordship's officer, the copy of this.
My lord, I pay for the petition in this matter, my lord. My lord, pursuant to lordship direction, my lord, I have already drafted, my lord, the affidavit in opposition, my lord, and my lord, the reply, affidavit in reply, and I have sent it, my lord, for vetting and approval, my lord, to the department. It has not come, my lord.
This third time, my lord. Since there is an interim order. 10-10, we have served the affidavit
First time,
opposition.
after opposition, this is the first time.
10,
So, my lord, I have already sent it, my lord. So, my lord, only, my lord,
This is a fairly placed, my lord.
my lord, lordship conditions, my lord, if I'm, my lord, I have already prepared and I have sent it, my lord, for approval, my lord.
Yes,
I have already sent it, my lord.
You have the interim order.
Yes, interim order is there, my lord.
Union of is opposing.
So, my lord, only, my lord.
You will curtail your enjoyment.
That is.
My lord, what kind, my lord, lordship, my lord, I should, my lord, say, my lord, that this is the affidavit.
Prasad requires approval of any further authority.
My lord, yes, my lord, your lordship knows, my lord, government office, my lord.
At end of January.
Railway.
End of January, interim order is there.
Your end of January, it is there interim order.
Yes.
If you don't make it within 11th, we will not extend.
11th,
We make one point clear. You tell us when you will get the approval, but if you do not do it, we will not extend the interim order.
By 16th, my lord, I will come because, my lord,
It
the
is recorded.
person concerned, he is not. In the
We do not know anything. It is
by
understood.
16th, I will, my lord.
We are keeping it according to you.
16th.
If you fail,
My lord.
please don't pray for
I, my lord,
extension of
yes, my lord,
interim.
yes, certainly.
This is understood.
Yes, 16th, my lord. By 16th, my lord, I will do.
Mr. Prasad, learned advocate appearing for the petitioners, prays for extension of time to file the affidavit in reply. Stop. As a last chance, comma, time to file such reply is extended till
Lord, 16th of January.
As a last chance, my lord.
Last chance, bole dijiye.
কবার দুবার লিখবো
No,
as a
no,
last
no.
chance. As a last chance till 16th it will be.
I will try my best.
No, try, not try, don't tell us.
Then 21, my lord.
21 is a Sunday.
But
You're
20
coming.
my lord,
22nd.
22nd, my lord.
22nd is the matter for further consideration in the daily supplementary list of this court on 24th. 24th.
I'm deeply obliged, my lord. Yes.
But you must
Yes.
you must give a copy to him on 22nd.
Yes, I will give. I will give him.
Don't say that I am now handing over the
No,
copy.
by 22nd, I will give him. This time it will be, my lord. I'm grateful.
Why, what order, pension?
No, my lord, this is a I am working as a bungalow peon. I have been terminated at the time of COVID. The officer has been terminated without approval of the chairman, my lord. My lord already dealt with the issue, my lord. My lord passed an order.
My lord, he has
They
not
have passed a
completed,
law
my lord,
order.
120 days. My lord, 120 days he has
No, no,
not
that is
completed. And he is
everything
not
has been
sufficient.
completed.
I will come.
He's saying we have passed an order.
Everything has been completed. 240 days I have been completed, no break.
20
I have
days,
already
I
attained
will show
temporary
one of the
status.
documents.
Mr.
And even,
Prasad, you should not be so
my lord,
unkind.
my lord, this fellow,
Bungalow peon.
my lord, this fellow has, my lord, made a bold allegation against the officer with whom he was attached. He is saying that he has demanded
Sorry.
money from him to make him, my lord, permanent and all. Lordship, can you see how concocted and manufactured story has been made, my lord? I will, my lord, place.
You cannot make a concocted story, no?
My lord, my
You
lord.
said just now that how concocted story we have
My lord,
made.
how he, my lord, a story was, my lord, hatched up.
Yes, 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 yes.
SC Prasad. বাবার নাম লিখে নেবেন।
We have been declared
বাবার নাম
and
Yes, my lord. My lord, there is a two division bench order. One is, my lord, decided by my lord, and another is, my lord, Justice Horiston. This is the order. পরে দিচ্ছি, পরে দিচ্ছি, ma'am.
you went to Supreme Court, huh?
No. This is against the railway also.
Anyway, come on that day, Mr. কি ভুলভাল
আর একটা কপি দিচ্ছি, পরে দিচ্ছি, কপি একটাই আছে। ডাব্লিউবিসির নামটা বলে দেয়। কপি দিয়ে ভোট দিচ্ছি, আমাকে একটা করে কপি আছে, দিয়ে দিচ্ছি, ওদের কাছে আছে।
But even if they take it as do work, it has to be self-building. That much easily has it.
এটা দিয়ে দাও
ডাব্লিউবিসির নাম্বার লিখে দেয়, লিখে দিচ্ছি, দিচ্ছি।
Mr. Prasad, yesterday that day we were dealing with the matter where a part-timer in postal department, he was thrown away. So that was a temporary engagement. So he went to the tribunal and filed a matter for regularization. So tribunal said that regularization is not permissible. Just we are discussing out.
Oh, yes, yes, yes.
But before that final order was passed, tribunal passed an interim direction that on record I find that one officer has recommended, did please take follow-up steps. But that ultimately merged with the final. So the matter after dismissal it came to see how advocates help. You are our officers. So there is no scope for regularization now. But he was a bungalow peon type, receiving
temporary
100 rupees or 50 rupees per day. So I asked the advocate that very good, we will, as regards regularization, you also know the prayer, it is very difficult to. But he was a peon working stopgap arrangement. Why don't you ask your officer and engage him somewhere, anywhere you want for 200 rupees per, that is the, and they can throw away at any time. So the advocate agreed. He said that, all right, my lord, I am speaking with my officer and I'll come. Believe it or not, it was done. The person has got that answer. This has been for the assistance of the advocates rendered. No?
Yes, yes.
Because you also, when you go through the matter, you will come to know at one juncture that whether it is a good matter or a bad matter. That also you know. So we would expect, yes, he has done a wrong thing. Why he should abuse his earlier officer? That is not proper. You cannot make false. But if there is a question of livelihood and if at all possible, so you can apply your good office and come back to us and say, and whatever protection you want, we will give. will appropriately control the person. Just keep this thing.
I'm grateful, my lord.
But was that came now? That lady was he got the job. What you are blessing? You are and you are saying no.
Lordship, item 19, I am for the respondent. I am being led by Mrs. Chandri Alam. She was in court, but for her health issues, she had to go back home. So kindly praying for not today.
What
Lordship.
happened to her? I found her just now.
Yes, she had to go back home. She was suffering from fever from yesterday, but
2
she
weeks?
yeah,
2 weeks. Or not this week করে দাও।
not this week. Lordship. Not this week.
এই কোনটা আবার 4টের সময় ফেলছো?
Your Lordship, in this matter, I am appearing for the petitioner. Pursuant to Your Lordship last order, the respondent ought to file their reply, but till date, my lord, I have not received any reply so far.
So I'm paying for 3 weeks time to file my
Who is at fault? Who is at fault?
I am not the right person to decide the.
We will penalize you.
Your Lordship.
Mr. Banerjee.
Yes.
Huh? Mr. Banerjee.
Lordship
that is
knows
why-
better than me in that.
My lord, only one submission. My lord, kindly takes my lord's order. The last page 3. Page 3 of your lordship's order.
Just. Hmm. Yes, which one? What you are saying, Mr.
Yes.
Banerjee?
My lord, over here, your lordship's prima facie view was with regard to non-inclusion of some of the witnesses, on the basis of which some of the statements or the statements which we purportedly may rely upon, but those have not been included in the list of witnesses. On that basis, your lordship has been pleased to admit the petition and pass an interim order staying all the proceedings.
Hmm.
My lord, in the meantime, the department has been pleased to, my lord, instruct me that they want to amend, that is the disciplinary authority wants to amend the charge sheet.
Amend the charge sheet?
Yes, my lord. My lord, these are my instructions. And they have also referred, my lord, in the next page.
Is the petition, Mr. Bhushan, he is in suspension?
No.
He's in job. He's doing
He's
regular.
doing his regular.
So very good. We will solve problem, get solved.
My lord, this is the instruction.
No, then Mr. Banerjee, why don't you withdraw and we will say that you would be at liberty to proceed afresh in accordance with law.
My lord,
So far the amendment is concerned of charge sheet, my lord. They are imposing their Article 311. They are issued the Rule 14 under major penalty. And here they cannot,
my lord, only
at
with
their
regard
own
to-
wish, my lord, they cannot change the modus operandi of their charge sheet.
The present one is challenging the charge memo.
No, the present one which your lordship has been considering is with regard to the merits of the charge sheet and with regard to some statements have been purportedly relied upon in the charge sheet. But my learned friend has argued that those names have not been included in the name of witnesses or in, as relied upon by the prosecution. On that basis, my lord, your lordship has been pleased to grant an interim order of stay.
This is one of my argument, my lord. The rest of the 3 argument has not been addressed by learned friend, my lord.
The same charges like they will do it by producing it. So they want to amend the list of witnesses.
List of witnesses.
And the other argument which he made as regards violation of the circular.
Yes, circular as well as the vagueness of the charge sheet. These points has not been rebutted my learned friend, pursuant by way of an
will-
affidavit.
My lord, only with regard to the present contention, your lordship has only considered the arguments with regard to this witness.
Admission, one
Yes.
point was considered.
Yes.
Valid. The
But
matter.
it is not, we have not stated that other points we are not going to decide.
Definitely, my lord, we have to address those points. But with regard to this point, I have been instructed to, since your lordship is in session, arbitrary decision of the DA, my lord, that is the reason why to amend the charge sheet, my lord, since your lordship has passed an interim order of stay, that will be otherwise taken care, I mean.
If, my lord, the arbitrary decision of a DA for the issuance of the charge sheet, how that charge sheet can be tenable, my lord?
আরবিটারিটা আমি বলছি যে জজ স্যার ভাবতে পারি যে আরবিটারিনেস হয়েছে
আপনি বলছেন যে নিজেটা
না
আচ্ছা।
Charges will remain and the other points will remain.
What was the charge?
Charge, my lord, is the misappropriation of fund, or that allegedly in a while posting in.
How you will be prejudiced if they are allowed to include the witnesses whom you would be in a position to cross-examine?
Yes, my lord. Pursuant to, I just want to recapitulate the fact which I argued on that day, my lord. What was my point of submission? I took the plea that the charge is vague because the entire charge sheet is the copy paste of the DRI, Department of Regular Intelligence mechanism, whatever they stated, that taken into consideration by the disciplinary authority and made a copy paste. So there was a vagueness, so there is no definite article, number one. The second point which I have taken, the departmental circular, which as your lordship has already mentioned this departmental charge sheet, departmental circular, that has not been taken into consideration while framing of the charge sheet, my lord. These 2 points. The third point, which lordship feel pertinent, and having the substance on that, your lordship taken into consideration of non-inclusion of a person whose statement has been given in a part annexure 3, but that has not been considered in annexure 4.
My lord, these are my instructions for your consideration. Thereafter, my lord, we shall.
So, Mr. Banerjee, you do one thing.
Lordship.
Whatever is your intent,
We take out an application.
you express that in your
Affidavit.
opposition. We have already asked you.
Yes, my lord.
Yes.
Did we ask you to file an opposition?
Yes, my lord. Kindly extend it for 2 weeks or 3 weeks, actually. 3 weeks. We are ready with our opposition.
Yes, challenge the charge sheet itself today.
Yes.
If this amendment is allowed, the charges will remain.
Definitely.
If the charges remain, his grievance also remain.
Yes.
So we will consider his argument, consider your prayer, and dispose of the matter.
Lordship.
Otherwise, it will create
Lordship,
further
Lordship.
Yes, sir.
And Mr. Day, you are appearing for whom?
For the DRI.
3, my
Who is that?
DRI.
DRI.
Director of Revenue Intelligence.
You have no role to play.
So far, this disciplinary proceeding is concerned, I do not have any such role to play.
So
But I carried out the preliminary investigation under the Customs Act. Pursuant to that, a show cause notice has been issued under the Customs Act. And that is right now in subject to correction, that adjudication of the said show cause notice is going on. But this is pursuant to our investigation, disciplinary proceeding has been initiated. That is what the petitioner wants to contain.
Then what show cause you have issued?
We issued a show cause under the Customs Act for the violation under the Customs Act.
No, he is a railway employee.
No.
Customs Department employee.
So he's a customs
Yes.
department. Now you conducted a preliminary inquiry.
We conducted an inquiry or investigation under the Customs Act.
All right.
Or violations of the or infractions of the provisions of the Customs Act.
And that has reached the show cause stage.
That has reached the show cause.
Very good. And Mr. Banerjee's client has?
Mr. Banerjee's client is the disciplinary authority of the petition.
Oh.
My lord, that materials which the misconduct which the DRI has found in respect of the conduct of various activities as an officer of the customs was not in consonance with the.
All right, Mr. Banerjee, learned advocate, you use also opposition.
I will also use the opposition.
Mr. Banerjee, learned advocate,
Appearing for respondents 1 and 2. You are for 1 and 2?
appearing for
No.
the respondent numbers.
I am for the 5,
Who is-
respondent number 5.
You are, you,
I am for the two. Commissioner Bolpur.
Commissioner?
Bolpur. He was working under me. I
Fourth
posted him
respondent.
there.
Fourth respondent?
I am the respondent number 2.
No, you also want to use an opposition?
Yes, ma'am. Yes, ma'am.
Who is for respondent number 4?
Okay.
Commissioner Commissioner of Customs.
Mr. Banerjee can appear, no?
Yes, madam.
4 and 5.
5 I am appearing, but for 4, madam.
4 I will appear. Customs, Commissioner Customs.
You are appearing.
I will.
लिखे दाओ the respondents. None of you have filed your opposition.
No, madam. None of them have filed their opposition.
The respondents appearing, the learned advocates appearing for the respective respondents pray for extension of time to file the affidavit in opposition. Let such prayer is considered and allowed. Let such affidavit in opposition be filed within
2 weeks. Madam, my name will be ready. It is
within 3 weeks. The reply thereto, if any, be filed within 2 weeks thereafter. List the matter for further consideration on 19th February.
Lordship.
3 weeks, 2 weeks হচ্ছে তো আজকে কত তারিখ 1 2 3 19th the interim order passed earlier is extended till the end of February 2024 or until further orders, whichever is earlier.
Madam, with regard to the amendment of the charge sheet, madam, any observation by your lordship, madam, so
So
far?
let that come on record. You will certainly say that. So you are accepting that charges for proof of the charges their requirement is necessary. That is why you disclose that in your opposition. We will
Because, my lord, that is within.
The charge memo also has to be served on.
Don't make any amendment at this stage.
That is the reason why, my lord, I have not.
No,
Yes.
when court is in sitting.
Definitely.
But it may be your advice to your clients as you can proceed.
Definitely,
We have
that
not
is the reason.
injuncted you from amending the.
Definitely.
Yes.
Since your lordship is in session of the matter, madam, we must restrain ourselves from doing anything which.
No, our interim order is
Restrain
restricted
to the disciplinary proceedings.
You cannot prevent, if there is a decision of the authorities to that effect, you can highlight that in your opposition. Then, yes, আপনি চারটে কি আছে?
Deep replacement.
এই ব্রিফটা দে তো ভাই, আমার কাছে ব্রিফ নেই। এটা আমি নিয়ে নিচ্ছি।
Yes, my lord, I have brought the check with the current date. This is there. My lord, my client has asked me to make a few submissions before your lordship.
Yes.
Yes, my lord. I am abiding by what has been fallen from your lordship's observations, my lord. My client is complying, my lord. He is paying 10 lakhs of rupees, my lord. But what I was submitting, my lord, because if my lord said that I had argued. Lordship would remember, my lord, my learned friend had argued. I did not argue at all, my lord. In fact, it came up from your lordship that I should kindly just bear with me. Lord, what I was submitting, my lord, is this. My learned friend has stated that my stay has been rejected. It was not so. The learned tribunal, my lord, said that it is a premature application because the order for enforcement of the time for enforcement of the order passed by the learned rent controller has not arisen as yet. On this ground, my stay was not considered. That is a clear-cut observation and recording in the order. That will I can show to your lordship. That was the thing. From this order, I had filed the writ petition before the Honorable High Court. The WP LRT 169 of 2022.
That was not heard along with this.
No, that was heard by my Lord Justice Basak. That was heard by my Lord Justice
এই
Basak.
আমার ফাইলটা কোথায়? না, না, no, you have challenged order of 6th October 2020.
No, my Lord, 6th October that I am not liable to pay the further amount of rupees 2 lakhs that has been granted. I am not on this. What I was submitting.
No, we are 6th of October 2023 was challenged both by you as well as
by me. I am not talking about the present.
Now, this order was passed in OA 3474.
Yes, my Lord. Now, my Lord, the first order, my Lord, I was submitting with regard to the order passed by the learned tribunal on November 2022, 18 November 2022, whereby, according to my learned friend, my application for prayer for grant of stay was rejected. That is what he has submitted before your Lordship. Lordship will consider by that order of 18 November 2022, my stay was not considered and rejected on the ground that it is premature and the time has not ripened to comply with the order passed by the learned rent controller. On this observation, my application was not considered. It was not that on merit my application was rejected by the learned tribunal. Brief it, bundle of that is yes. That is the first submission. Secondly, what I was submitting, that the first payment was directed by the
Yes.
That was the first order, 18 November 2022. My writ petition was pending before this Honorable Court. In the meantime, in the month of July 2023, my Lord, on 21st July 2023, the learned tribunal passed an order directing me to make payment of rupees 2 lakhs. My Lord, this payment was directed to be made, my Lord, if my stay would have been rejected on the ground of merit, my Lord, my learned friend could have enforced the order then and there that the entire amount has become due and payable in terms of the order passed by the learned tribunal. Then, my Lord, the learned tribunal on 21st of July directed my client to deposit 2 lakhs. Though initially I had applied for recalling of the order, but subsequently, my Lord, as advised, my client made payment of that rupees 2 lakhs as directed by the learned tribunal. Now, from this order of 21st July 2023, my learned friend has filed the writ petition before this Honorable Court, which was considered by the Honorable Division Bench presided over by my Lord Justice Basak. My Lord, and my application was also appearing along with that application, WPLRT, which was filed earlier from a different order. Both the writ petitions were taken up for hearing. My Lord had the prayer in the present writ petition filed by my learned friend and the earlier one your Lordship will consider is identically same. My learned friend at that point of time also had called upon the respondent, my client, to pay the entire amount which was not granted by the Honorable Court on the ground that entire matter will be threshed out within a very short span of time. And then you have already initiated eviction proceedings against the respondent. Now, my Lord, on the basis of that order, my Lord, both the OAs were directed to be disposed of within a period of 3 months. In light of the order passed in my learned friend's writ petition, no order was passed in my writ petition because the Honorable Court was of the view that if the matter is being heard expeditiously, nobody would be prejudiced. And for this reason, Your Lordship, the order was passed in my writ petition 16 September, that in light of the order passed in my learned friend's writ petition, no order is being passed. Thereafter, my Lord, my matter was heard before the learned.
Madam, are we required to go into this?
My Lord, the reason is, my Lord, why I am saying so.
What is the reason? Tell
us.
The
reason is, my Lord, that
you tell us what protection you want.
My Lord, I want, my Lord, this, I'm paying this amount. I've already paid 7 lakhs plus this 10 lakhs, 17 lakhs.
We are asking
yes,
since
10,
morning.
I'm asking Lordship, the stay of the rent controller order. I will pay this without prejudice to my rights and contention. Tribunal has also directed that this will be adjusted from the rent which will be determined. This deduction is already there with regard to the 2 lakhs I have paid and the further deduction of 2 lakhs. That will be there, my lord. But I want, my lord, the stay of the operation of the rent controller's order till the disposal of the appeal by the learned tribunal. This much I want, my lord.
That stay has not been granted. That is to be considered by the tribunal.
We can do some protection. What protection?
Your prayer for stay was considered. It was not refused. It was sent back to the tribunal for hearing along with his application.
No, not my stay. My both the appeals were directed to be heard on merits. Neither any direction was made to make payment of any amount
Right.
to my client. No payment direction was made.
Now
by,
the suit which he has filed,
let my lord learned friend, if he proceeds with the suit,
your
my lord,
stay which was refused because it was premature as stated by the tribunal has not been interfered with by the High Court.
No, my lord,
High Court, if you say no, my not on every sentence, it becomes difficult.
sorry.
That has not been touched by the High Court. High Court has relegated for the tribunal to consider. Is that true or not? Your prayer, I understand, there was no refusal of the stay according to you. The tribunal, while deciding his application, along with that, has sent it back.
No.
So now the stay issue, it is admitted that stay has till date not been granted. Tribunal did not grant since it was premature, but it was not rejected, as you have said. So now the tribunal will hear the issue of stay. Now, second point which you argued was that about the title suit.
My lord, title suit I am not pressing because it is not the subject matter of the
Madam,
LRT.
tell us what
I am
protection
asking
you-
now because since pursuant to your lordship's observation,
as you are paying 10 lakhs,
I'm paying 10 lakhs. I'm paying for stay of the rent control order. Eviction proceedings I am not asking for. My client will contest
So
whatever
that
may be
means
the
we
fate.
are taking away the thing which has been asked to be decided by the
No, my lord.
by
Kindly
the
see.
High Court.
Kindly take 16 September order passed by the Honorable High Court. My lord, coordinate bench of this Honorable Court. My lord, just can I hand over the compilation?
See, now what is your, see, what protection you need, you tell us.
My lord, I am just.
Stay, you leave about stay because stay we cannot grant since already writ petition 169 was disposed of. Therefore, 1 second. Now, what is your next prayer? Why you are afraid? Why you are afraid? Eviction suit.
No, my lord, what I'm saying is, my lord, otherwise what will happen, my lord? This 10 lakhs, the payment which I am going to make, my learned friend will again, third time, will come up with an application that I should make payment of further amount, which he has done regularly.
Record. 1 second,
Yes.
listen. He will not ask for further payment till disposal of both appeals. That we will record. What else you want?
And my lord, what that I was submitting that
the date has been fixed in July.
in July
we will
2024.
we will say that you are paying 10 lakhs. He will not be making further prayer for payment till the disposal on July or on the date fixed thereafter. We will give you that. We are asking him in his presence.
And my lord, the amount which you are paying as a lump sum, and my lord, it should not be
Counsel, you
treated
have
in
to
compliance
understand.
of the order passed
You
by
have
the
to
letter.
understand. Keep on making submission. We cannot help you. You must understand.
Yes, Mr. Roy.
One
Anything else?
One rectification. Your lordship kindly to see page 101. My lord, my lord, one thing. Your lordship page 101, my lord. WPLT 125, page 101. Because my lordship says that I am making a wrong submission. Page 101.
Yes.
WPLT 125. Considering middle portion.
You read the paragraph previous to that.
Considering-
You cannot jump on the conclusion only.
No, we are not jumping. We have.
No, I'm saying my learned friend.
Considering
See, you cannot make submission on either. You have both of you have to address the court.
Yeah, I'm sorry, my lord.
You don't interfere when others are arguing.
Considering
Considering as such and having considered all the above aspects without touching the merits of both the original application and without causing any prejudice to the rights and contention of the parties, the prayer for stay of operation of the impugned order stands rejected.
In view of the preceding paragraph. That
Very
it
well.
is- It is premature, so it is rejected.
Yes, Lordship. Next, they have never paid 169
We
dismissed.
understand. We understand.
Now-
Our argument is that this is not total stay.
Now,
Total
after
rejection.
now
It's
in
not
view,
total rejection.
now in view of section 3F of the West Bengal Premises Tenancy Acts,
See, both of you, please listen. Now we want to give a quietus to issues. So both of you, please understand and answer to our query. See, now we will ask the tenant to pay 10 lakhs. According to her, she will pay 20 lakhs today. She will give check and other 3 lakhs in installment February and March. You receive the 3 checks. Till disposal of the appeal, July 2024, you don't ask for any further amount.
how
Let
it has
us-
been, my lord?
Then
There
let
has
go.
been huge,
Then
there has
how
been
it is
huge
possible
dues,
that
my lord.
both of you argue the case on
Because
this?
there has been a huge dues, my lord.
No, we will say, Mr. Roy, that the date has been fixed on July. Your matter has been fixed
My lord,
on
what it
July.
happens in earlier occasion, Justice
We are not- we are not-
Justice Bosak in his order says that this will take 2003 to 2022, 19 years. So Justice Bosak directed the tribunal to dispose it of matter within 3 months. Now, after seeing this order, the chairman fixed the date after 9 months, 18th July 2024.
Then
Specific.
what do you want it as?
My lord, I say that there has been a huge dues every day. Very well. Your lordships, kindly to see the last page of my order. One thing, documents I have cited before lordships. Page 166. Bas, nothing. One page. Your lordships, kindly to see page 166.
Problem that not understand.
No, this is my last submission. I will not prolong you. Before losses, 166. He is paying monthly electricity charges 24,000. Now
Correct,
page
that we understood.
171. Your losses kindly to see.
Commercial property, you are paying more, but he is not the only tenant. There are lot of tenants are there. He is not the only tenant. So you understand, you receive 10 lakhs and till July 2024, we will ask the appeal court to dispose as expeditiously as possible on July 2024 or any other date without giving further adjournment for both.
Very well. But
Yes.
but injunct me to pay for further amount, my lord. There is a every day.
Then in that case,
Your losses.
we have to allow your appeal, your writ petition.
Lordships,
Your
I am.
writ
This is
petition
my
is
humble
what?
submission, my lord. This is my humble submission. It's the
Submission,
court.
that's what submission we are accepting means we have to decide the case on merits. Instead of that, we convinced you, both of you, and that's why we asked your client to come here.
My lord, I am.
And after that, then
These
you
are
can
starting arguments, but I am not saying
After
he is
that,
starting
when you
arguments, my lord.
start arguing the case, then what is the purpose?
I am not saying, my lord, he is starting his case, arguing this case.
Today you were not with any amount, Mr. Roy. It is due to our endeavor. Because
Lordships,
telling
lordships.
you will
Yes,
be
lords.
getting 10 lakhs.
Lords.
We understand your
Yes, lords.
anxiety, but the thing is, we are not deciding the matter on
Lords,
merits, Mr.
Lords, yes, yes, yes.
In 2-line order, we can dispose it of.
Lords.
So that's what without deciding. Petitions are the tone for court is that to restrict the appeal, that means that we have to research some. That means if this is satisfied, till disposal of the appeal. Till disposal, we will not ask for further. Yes.
Because Prasad said
Then
fix the matter.
that also we have to say. Where is that order passed by the coordinate bench?
That within
to
3
dispose
months.
Within 3 months?
Your
With
lordships,
order.
to see page.
Not completed.
Page 149.
Yes,
Immediately after placing this order, chairman of this tribunal fixed after 9 months. Is so aggrieved by this order. Page 150, operative part. Since the litigation is the age of 19 years,
There, parties agreed next date of hearing.
They will not do it.
Question
Question
not
not
to,
to-
Granted any further adjournment will adjourn.
Endeavor to adhere to the timeline. We had 3 months given.
My lord, page 150,
Hmm.
middle portion, in such circumstances.
This paragraph.
In such circumstances.
Because there would be appropriate to direct the course within a 3 months.
Preferably, that is why they. You don't want to be no, not easy for me. It's like only
So that you tell this something, right? So go to 19. Even after that, date 16 July 2020. It will be ending for the adjournment.
they will not come up. We have to approve the chairman. So can we do this? Both the writ petitions have been preferred.
My lord, may I just hand over the check to your lordship so that it can be recorded?
Yes, get the check. Three checks are due. Take photographs and keep them in file. While taking the file, you get the receipt.
In the writ petition being WPLRT 125 of 2023. 125 is landlord. 125 is landlord.
123
In the writ petition,
In the writ petition being the PLRT 125 of 2023,
subject matter of challenge is an order dated 6th October 2023 passed in the original application being OA 3474 of 2022 preferred for enhancement of rent already assessed by the rent controller. Stop. The other writ petition being WPLRT 123 of 2023 has been preferred against an order dated 6th October 2023 passed in the original application being OA number 3297 of 2022 preferred praying for reduction of the assessment of rent preferred by the tenant করে দেবে হ্যাঁ আর ওইটাতে বলে দেবে by the landlord ঠিক আছে in course of hearing of the writ petitions analogous detection আছে analogous শুনতে বলেছি analogous stop in course of hearing in course of hearing Miss Agarwal learned advocate appearing for the tenant submits that the tenant, namely that there are two tenants. There are two tenants.
Joint tenants.
Joint tenants. Submits that the tenants are agreeable to pay an amount of rupees 10 lakhs on installments in 3 installments to the landlord.
This person.
Three installments.
Landlord,
My lord, there is a, because the reason one is that writ petition is filed by Anil Kumar Poddar. Writ petition, but the rent is being paid in the name of Anil Kumar Poddar HUF.
We will write.
Yes.
Whoever, you listen to our order.
Don't interfere by dictating.
Yes, listen to our order. If we are wrong, you correct. You will, in course of no, in course of hearing, Miss Agarwal, learned advocate appearing for the tenants, submits that in terms of the what he's paying, that submits that the tenants are regularly disbursing the amount of rupees 3,366.
Agreed rent.
The disbursing the agreed rent of 3,366 per month to the landlords.
To the rent controller.
Sorry, to the rent is depositing.
If my land friend accepts that, I can pay it him directly. If they accept.
Depositing before the rent controller. Stop. And that the tenants are agreeable to pay an amount of rupees 10 lakhs, further amount of rupees 10 lakhs to the landlord, in 3 installments. Stop. Mr. Roy, learned advocate appeared.
Brought 3 checks dated.
My lord will also record that 2 lakhs we have already paid before in terms of the earlier order.
Please wait.
Mr. Roy, learned advocate appearing for the landlord has agreed to accept such payment of rupees 10 lakhs by 3 employments, in 3 installments. Stop. In view thereof, দাও দেখি এবার চেকটা।
Don't give it to them. Don't give them.
Miss Agarwal has placed before us 3 checks.
Positive pay system.
Issued in the name of Anil Kumar Poddar bracket HUF.
Whether they have account.
Mr. Roy, do you have the account in this name? Please check.
Yes.
Check.
HUF.
Yes.
HUF is
Yes.
there.
HUF is not that.
You might face problems.
No.
I think he didn't understand. In bracket HUF is there.
Yes.
Account is there.
Previous occasion, 2 lakhs had been encashed in HUF. Yes.
কি লিখেছো? Miss
Issued in the name of
placed before us.
Has placed before us 3 checks issued in the name of Anil Kumar Agarwal HUF.
Anil Kumar Poddar.
Anil Kumar Poddar, বাবা আস্তে আস্তে নাও। Poddar HUF dated 4th January 2024, 16th February 2024 and 16th March 2024.
Bearing check numbers dated for.
Bearing check numbers 0069444, 00695, 00697 respectively. Let Xerox copies of the said checks, let Xerox copies of the said checks be kept on record. The above checks have been handed over to Mr. Anil Kumar Poddar, who is present in court today. And he has duly received the same
And made endorsement.
duly received the same and has issued a receipt thereof. Receipt not required? আচ্ছা।
Why not let it be in the order? We don't.
Stop. এইটা ওই মিস্টার রয়কে দিয়ে দাও।
See, you take Xerox, don't give it to them.
জেরক্সটা তুমি রাখবে, ওই তিনটে চেক ওনাকে হ্যান্ড ওভার করে দাও।
See, here
কি
it is,
অফিস
they know
থেকে?
that.
জেরক্স করা নেই?
In our printer,
We have given the
there
Xerox
no
copy.
Xerox.
My lord, we have given the Xerox copy of the check also.
কোথায়?
Yes.
হ্যাঁ, ওই করে নাও না, কি হয়েছে?
ঠিক আছে
অসুবিধা নেই, একজনকেই থাক না, এই তিনটে রেকর্ডে রেখে দেবে।
Lord, just only one submission, my instruction. Just one.
দাও না, let us complete, then you may.
The last one.
হ্যাঁ।
947. 947, yes.
Records reveal, next para dao. Records reveal that in the earlier writ petition preferred by the landlord being WPLRT 107 of 2023, a coordinate bench of this court requested the tribunal to hear and dispose of the original applications as expeditiously as possible and preferably within a period of 3 months from the date. However, it appears that the next date of hearing has been fixed by the learned tribunal on 18th of July 2024.
Yes.
Stop. 18. Stop. As the tenant has agreed and paid an amount of rupees 10 lakhs in 3 installments through issuance of necessary checks to the landlord, comma, we direct that the landlord shall not claim any further amount till 18th of July 2024. এইটার আগে as কি প্যারাটা বলেছো? However, next date has been
However,
fixed
it
on
appears that the next date of hearing has been fixed by the learned tribunal on 18th July 2024. As the
তারপরে
tenant
ওইটার আগে আরেকটা প্যারাগ্রাফ দাও। Stop. क्या करें? How much time will it?
We have proceed. The tribunal is directed to complete the hearing after earlier direction on the fixed date. If not, another within 1 month. You know, the same student.
अच्छा,
Within 1 month thereafter, this.
has been fixed on 18 July 2024. Stop. In view thereof, we direct the learned tribunal to dispose of the original applications on 18 July 2024 itself, or within 2 months thereafter, without granting any adjournment to either of the parties. Stop. তারপরে লিখলে কি? In view there shall not pray for any further enhancement
We direct that the landlord shall not claim any further amount till
shall not
Enhancement, further amount.
further amount till 18th of July 2024 till the disposal of the original applications on 18th of July 2024 or within 2 months thereafter. However,
Original appeals. Appeals, application, appeals. Application.
original applications.
297 is application.
Yes, yes.
Oh, I thought
This-
appeal.
this-
Yeah, I thought
However, in the event the original applications are not disposed of within the above period, within the aforesaid period, comma, the landlord would be at liberty to make appropriate application claiming for further claiming further amount.
My lord, to this, my lord, I have objection, my lord.
Stop. Yes.
My lord, to this,
Recording.
my lord, to this, my lord, my lord, kindly.
Stop. আরেকটা কি বললাম জানো? It is made clear that the amount of it is made clear that the payment made by that the tenant has made the payment of rupees 10 lakhs without prejudice to his rights and contentions in the original applications as well as in the pending title suit. Stop.
My lord, both the parties.
Both the parties.
Both the parties.
Made clear without rights and conditions of both the parties in the original applications and the pending title suit.
My lord, may I just make one?
দাঁড়াও বাবা, চলে যাচ্ছি না। Next, দেখেছো তো? What did he, anything add?
That's all. To give a direction, both appeal, both
Stop.
petitions are there.
The learned tribunal will dispose of the original applications without being influenced by any of the observations made in the present order. Stop. The writ petitions being WP such and such are, comma, accordingly disposed of. There shall, however, be no order as to article. Yes.
My lord, what I was submitting, my lord.
এই চেকটা দাও।
My lord, my lord, kindly just hold the check for a minute, my lord. Kindly hold it for a minute. My lord, I had pressurized my client to pay this amount on the ground that appeals will be heard. And my lord, he will be subjected to further payment after on the result of the original application. Otherwise, in light of the order passed by my division bench, ordinate bench of this honorable court, my learned friend was not entitled to any enhancement. My lord, your lordship has granted my learned friend the liberty to seek for enhancement of rent after September. Then, my lord, he will again come up with the same prayer that I had to pay the entire amount of the learned rent controller.
Direction to the tribunal.
No, my lord, your lordship has given the liberty to him. Kindly delete that liberty, my lord.
What
No, my lord. Otherwise, my lord, my client will not pay the purchase application. My lord, then my client is not agreeable to pay the amount. I have clear instruction, my lord. Let my learned friend argue his case. Otherwise,
you are pressurizing us.
my lord, I am not pressurizing. I have received this instruction from the client.
Pressurizing us.
My lord, I am not. My lord, I'm not. I
Are
cannot
you
do so.
pressurizing us?
I can never do so, my lord. I
Yes,
can
you
never
better
do so.
do not do so.
My lord, I am not doing so.
Our order, we finish it, comply.
My lord, kindly, this liberty, my lord, granted to my learned friend, my lord, that has been
We
done
have
by him.
said in the event it is
My lord-
not completed within July or September, he can make application for enhancement. Have we said that will be allowed?
My lord, that
Why
means,
don't you
my lord,
understand me,
my lord, the
otherwise-
moment your lordship gives this liberty, application for enhancement,
That will
that
be
would
your
amount that he will
understanding.
come back again, my lord.
But you will take.
My lord, otherwise, my lord,
Counsel-
my lord, can I give one suggestion, my lord?
Listen, if you don't give that liberty, you will take unnecessary adjournment.
I will not take any adjournment. We have never taken, my lord. May I suggest one way? My lord, that will be more better, my lord. This 12 lakhs deposit I have made. I did
12 lakhs today.
10 lakhs. 10 lakhs and 2 lakhs earlier. 12 lakhs we have made.
Before us.
Very well. 10 lakhs we have made. But what I was submitting, my lord, that we can do one thing, my lord, that will solve the issue, my lord, is this, that this amount of 8,817 per month, my client will keep on paying. That will be because otherwise he will come with for the area enhancement. Currently, I can say very well, we will pay.
Decided the case
No,
on
my
the-
lord.
We have not
In
decided.
enhancement, my lord. Otherwise, enhancement will come back with the earlier amount due and
This is
payable.
your anticipation.
No, my lord, I know that this is what
No,
has
no,
been
your
done in the
knowledge
past.
would not help.
This
That
has
is
been
your
done in the past.
anticipation. That is your anticipation that if 2 months, court has directed within July, we have extended the time. We have restrained them from making any prayer for enhancement till such disposal of the application in terms of our direction. And even if that after that the tribunal does not
Lord,
dispose
that
it of-
will not be that cannot be, my lord, my fault, my lord. That cannot be my fault if the tribunal
Exactly,
does not
that will
dispose
not
of
be-
the appeal.
exactly.
That cannot be my
Take
fault.
that prayer.
My lord, kindly, my lord, your lordship can subject my client to pay regular amount per month, enhanced amount by the learned rent controller per month. That I can appreciate. But asking him to, my client to pay the arrears amount in terms of the learned rent controller order will be very harsh to my client, my lord. He will ask for that. He will say that I paid 12 lakhs. He is entitled to receive further 24 lakhs. It will be too harsh for my client, my lord.
18th July, date fixed. 18th July, they have to complete.
If the tribunal does not complete
The case on the day, if there is any
the
problem.
tribunal, if the my lord, the tribunal does not
If there is any problem, you can come by way of extension of order. So you don't now it's
my lord,
you
kindly don't grant this liberty, my lord. This
no,
liberty.
What liberty we have
My lord,
granted? We have said that if there was an earlier direction for conclusion of hearing, that the tribunal
that I
has
don't
not
have any
done.
objection, my lord.
So now the tribunal has itself fixed on 18 July. We are not disturbing.
I'm
the
not.
date. We are saying that you dispose it on 18th or within 2 months.
My lord, what I
thereafter.
suggest.
Just a moment.
Yes.
And we have said that if in the thereafter only he would be at liberty. When the liberty is come, you will take the ground.
No, my lord,
that
then
it is not
lordship
my
will
fault.
also give me the liberty to apply for stay. Then that liberty, my lord, I should be also granted the liberty to apply for stay.
What?
No, my lord, kindly, my lord, what will happen, my lord, kindly just presupposes the situation. My lord, July, my lord, what I can foresee, you can, lord, I'm submitting, lordship can prepone the date. My lord, this liberty of enhancement, my lord, is causing too much hearts to my client, my lord. My lord, what I was submitting, my lord, it will, my lord, what he will claim for arrears. He will claim for arrears.
There is a limit, counsel. You have to.
Lord, he will claim for arrears. I know Mr. Roy. He has done it in past. This client has done it in past.
We cannot.
My lord, this has been done in the past. My lord, my client will be harassed. My lord, my client will be harassed. I can foresee, my lord.
We can make.
My lord, I request your lordship is this. Your lordship can prepone the hearing of the appeal. I do not have any objection. Instead of July, why I am submitting, why I am saying, my lord, why I am saying kindly, because the bench is going to be vacant in the, my lord Justice Suvasis Dasgupta, who is now presiding, my lord, will very soon be is at the verge of retirement. The bench will be vacant. That is why your lordship can prepone that. I don't mind, my lord, we will thresh out.
We are not rising.
We will thresh out the matter on merit. We are not running away. But the reason is he will again apply for enhancement instead of hearing of the appeal.
And that we are still, we say we do not pay for any enhancement. We will be granting a stay of the. Or how can we?
Lordship will not grant them liberty. If the enhancement is required, he can come back.
It's not a very early hearing. In that case, we will ask consideration.
They will not listen. They will not listen. We have never taken it. Okay, how can we know? আচ্ছা ওই লাইনটা কি লিখেছি বলো? It is made clear. হ্যাঁ সেটা হলো তারপরের লাইনটা কি দিয়েছো? By such as না ওটা বলেছি না dispose of the matter on 18 July or within 2 months thereafter. তারপরে লেখো তারপরের লাইনটা কি দিয়েছে?
Dispose of the original application from the or within 2 months thereafter.
এক সেকেন্ড অর্ডার অফ হাই কোর্ট
Page number 166, earlier order.
Yes.
When we say this in the evening, they will be able to reason for further influence and the tenant should reflect.
Stop that, right? Appeal is not disclosed. It's open to both the parties to renew their appeal. Both the parties to renew their appeals. We cannot say that stay. See, this relief would regard to 2 lakhs. Relief.
Stay. Stay has not been acted.
Stay.
We can one of term for
change
However, in the event, the original applications are not disposed of. না তার আগে বলেছো তো the landlord shall not make any prayer for will not make any prayer for further payment of further amount till 18th of July 2024 or 2 months
September.
or 2 months thereafter. Stop. It is made clear that in the event the original applications are not disposed of within the aforesaid period, comma, the parties would be at liberty. The parties would be at liberty to renew their would be at liberty
To approach the court for approval.
to pray for appropriate orders. The parties would be at liberty to pray for appropriate orders. All right.
Lordship, the
চেকটা দিয়ে দাও, মারপিট করে এবার চেকটা দাও।
Lordship, the
Milord, only what I was submitting, Milord.
Receipt.
I was no, I do, Milord, what I was submitting.
Yes, next, have you got the receipt?
No, they want.
No, your client
If
will
they can send it by later. Milord, what I was submitting, Milord, the banks now above 50,000, bank requires an intimation. Since I have issued a check today, I have to give intimation to the bank, then only it will be encashed. So let them present on instead of tomorrow, day after tomorrow. Intimation is law has changed now with regard to the check.
Roy,
Day after tomorrow.
You place it, let there be no return of check.
Lordship, item 20.
আবার চলে যাও, wait. একটু গোছাও। Yes.
Lordship, item number 21, Your Lordship, I'm praying for an adjournment for 2 weeks adjournment, Your Lordship.
Now,
Lordship,
we have
item.
called on 21.
No, Lordship, after 20, this item was called.
Ask your junior to remind us tomorrow.
Lordship. Grateful to Lordship.